time is 10:35 a.m. The Committee on Criminal Jurisprudence will come to order. Clerk will call the roll.
Chair Moody,
Present.
Vice Chair Cook,
Here.
Representative Bojani,
Present.
Representative Bowers, Representative Darby, Representative Harrison,
Here.
Representative Leach, Representative Christina Morales,
Here.
Representative Schatzline.
Here. Quorum is present. Thank you, members. Just a reminder for anybody that's here, anybody present wanting to testify before us, you need to register at the kiosks that are located in the hallways behind the hearing rooms. If you require assistance in registering or testifying, please contact the committee staff and we will make sure to help you out. I do want to note that in our posting we listed that we'll have a 3-minute limit on public comment. I'm going to have this high-tech device here to help us keep with that. I just want to be respectful of everybody's time. There's a lot of issues that we're going to be talking on, wide-ranging subject matter, but that way it gives everybody an opportunity. And that doesn't include questions that are asked of you. And so 3 minutes on a presentation, and then if we have follow-up questions, we can do that. Members, and I know I see members that have bills up, generally the process and the order we'll keep for everybody, just trying to keep notes, is seniority order for bills that we'll hear. Members of the committee, will go last. I will go very last if I have bills, which I do today. And we'll go seniority order within the members of the committee after non-members are here, so we can let people go about their business, right? That's always subject to change. If we got someone with 0 witnesses and we got someone with 20, and we'll try to make it work the best we can, but just generally for the public and for the committee members, if you're looking at the bills, that's how you can kind of anticipate that they'll come up, and then we'll shift and change that. Like I'll show, we just looked at these right now. Ms. T has several, but doesn't seem like she has too many witnesses on any of them, so we'll probably just move with hers first. Before I do that, though, let's see. I do want to refer some of the bills that we received to subcommittee. So the chair would refer the following bills to the Subcommittee on Criminal Procedure: HB 303, HB 311, HB 322, HB 352, HB 394, HB 399, HB 401, HB 405, HB 412, HB 414, HB 416, HB 467, HB 504, HB 519, and HB 559. The chair refers the following bills to the Subcommittee on Asset Forfeiture: HB 69. Let's get started. Chair lays out House Bill 247 and recognizes Dean Thompson to explain the bill.
Mr. Chairman, members, may I present the bill from this position?
Yes, ma'am.
I'm honored this morning to present this bill because we have a judge in the room, one of our former colleagues that I'm delighted to see. Welcome, Judge Phillips. Last session of the legislature, this bill was before us, and I think, if I'm not mistaken, we probably passed it out unanimously from the committee. Under the Texas law, individuals convicted of a crime generally have one opportunity to file a habeas petition challenging their conviction collaterally. People in prison often do this on their own without the help of a lawyer, and they fail to raise all of the relevant issues or fully develop them, so their applications are denied. This has become a barrier for conviction integrity units in district attorneys' offices throughout our state. When a DA's office investigates potential innocent cases and find evidence of a wrongful conviction, they can't rectify that conviction because of a previously filed writ application. This bill would allow the DA to waive the bar on subsequent writs when they believe, in their discretion, that the ends of justice will be served by allowing the court to consider a subsequent writ application. This bill gives district attorney's offices additional tools to address wrongful conviction. And I'd like to add that this bill was voted out of this committee unanimously and passed the Texas House last session 146-0. I will certainly appreciate your favorable consideration, Mr. Chairman and members. If there are any questions that I may answer for you, I'm available. If not, I reserve the right to close.
Yes, ma'am. Members, do you have any questions for Dean Thompson on this bill? Nope. All right. Now we'll figure out if I can work this. Chair calls Mike Ware. Okay. Hey, Mike. Welcome back.
Thank you.
I know you know how to do this, but your name, if you're representing anyone other than yourself, and your position on the bill.
Thank you. Good morning, Mr. Chairman. My name's Mike Ware. I'm representing I am the Executive Director of the Innocence Project of Texas, based in Fort Worth, Texas, and I'm the representing the Innocence Project of Texas on this bill. It seems extraordinary.
Your position on the bill?
I'm sorry?
Your position on the bill?
We're for the bill, I'm sorry. It seems extraordinary, but a great deal of our weeding out of otherwise legitimate cases and a great deal of time that we spend on cases is figuring out how to get a court to hear the merits of a very meritorious claim that is procedurally barred because it's a second-in-time claim. In other words, this individual may have filed something on their own or something may have come up and they've already had one writ denied. Therefore, there are statutory obstacles to them filing a second-in-time writ. Many times, those statutory obstacles can't be met. Now, let me give you an example. We've had 28 men and women that we've either exonerated or freed since I co-founded this nonprofit back in 2006. The last one was about 10 days ago out of Bexar County, Melvin Quinney. But we've got one coming up, James Reyes, in which the Odessa Police Department and Ector County District Attorney's Office has done an excellent job in investigating this cold case. Our client was wrongfully convicted, is completely innocent of a murder back in 1982. And thanks to the excellent work of the Ector County DA's office and the Odessa Police Department, he is likely going to be exonerated. Now, what if he had filed a prior writ that we could not meet the procedural burden on? Our hands would be tied. What this does is it allows a district attorney's office, if the district attorney himself or herself signs off on it, to waive this procedural bar and allow a case to be heard on the merits, which otherwise they don't have the power to do. It doesn't mean they have to agree to relief. They could still contest whether or not the merits merit relief, but at least it would allow the minister of justice, the elected district attorney, in their judgment to waive a procedural bar and allow the merits of a case to be heard. Otherwise, the Court of Criminal Appeals is likely to say, you don't have the power to do that. It's statutory. This obviously innocent person is procedurally barred from bringing a claim. Happy to answer any questions.
Mike, thank you very much. Members, do we have questions at this time? Nope. Thank you, sir. Chair calls Benjamin Wolf.
They can still contest whether or not the merits merit relief.
That was my favorite part, too. Do you have prepared remarks, or are you here?
Just oral,
Okay.
brief oral remarks.
Go ahead.
Good morning, Chair, members. My name is Benjamin Wolf. I'm the Director of the Office of Capital and Forensic Writs. I'm testifying on this bill. The Office of Capital and Forensic Writs is the Capital and Forensic Science Post-Conviction Public Defender in the state of Texas. Represent a number of individuals, or about approximately 70% of the individuals pending in capital initial post-conviction proceedings, and represent non-capital incarcerated persons incarcerated on non-capital offenses in cases referred to us by the Forensic Science Commission. To briefly dovetail off of the remarks of Mr. Ware, in our forensic practice, we get cases referred to us by the Forensic Science Commission, where the Forensic Science Commission, which is a great entity attached to the Office of Court Administration, will review cases, determine that the science is, the forensic science used in the case was bad, and refer them to us. And these are people who've been incarcerated for sometimes decades without lawyers. And in Texas, there's not a right to post-conviction representation on non-capital cases. And so that means that persons incarcerated will oftentimes file pro se writs without the assistance of counsel. And those pro se writs may have preclusive effect and impose procedural bars to later litigation. And so that's something that we're having to deal with in these cases where there are potential innocence claims. There's junk science that potentially affected their convictions, and the district attorney may want to see that justice is done, and the current law makes that difficult. Happy to answer any questions. Otherwise,
Thank you, Mr. Wolf. I appreciate.
Thank you.
Appreciate your time being here. Do we have any questions before we let them go? No? All right. Thank you, sir. Is that what we have? Is that it? Not registered. We're gonna leave it. Okay. Is there anyone else wishing to testify on, for, or against House Bill 247 at this time? If not, the chair recognizes Dean Thompson to close on her bill.
Mr. Chairman, witness, and committee, thank you for letting me present this bill, and I close.
Thank you, Dean Thompson. Members, I want you to think about this one really hard over the next couple hours as we have this hearing. And we might come back to it. But for now, if there's no objection, House Bill 247 will be left pending. Is there objection? Chair hears none, and the bill is left pending. Chair lays out House Bill 270 and recognizes Dean Thompson to explain the bill.
Thank you, Mr. Chairman, members. This bill is also about justice and public safety. Since 1989, 57 wrongfully convicted people proved their innocence with DNA testing in Texas. In these cases, 28 real perpetrators were identified and went on to commit 35 additional violent crimes, including 21 rapes and 2 murders. Chapter 64 of the Criminal Code creates a procedure for convicted people to access DNA testing and obtain relief. This bill lists 6 requirements for the trial court to grant testing. One of the requirements is the person must establish by a preponderance of evidence that he or she would not have been convicted if exculpatory result had been obtained through DNA testing. A ruling by the Texas Court of Criminal Appeals in 2014 limited the definition of exculpatory results and does not have to consider whether the person would have been convicted if the results generated a match to a third-party offender in law enforcement DNA database. Michael Morton probably would not have gotten tested under this current interpretation of the law, but was exonerated for murdering his wife in Austin based on DNA testing of a bloody bandana found near the crime scenes. You may remember, and I know Representative Cook does because he was working in the Senate at that time. He was a man that spent 25 years convicted of killing his wife. His children were so upset with him, they changed their last names. And years later, a bandana was tested, 25 years later, and the real perpetrator was found of this murder. And the guy finally got exonerated, and we passed in this state the Michael Morton's Act. George Phillip was a part of that vote. The facts that Mr. Morton's DNA was not on the bandana did not prove his innocence. It was the DNA profile that was matched to Mark Norwood in the database that proved Mr. Morton's innocence. This bill clarifies that the term exculpatory results includes the possibility that testing could result in a third-party match in DNA database. Mr. Speaker, Mr. Chairman, and committee members, I'm happy to answer any questions, and I reserve the right to close.
Members who have any questions for Dean Thompson on this measure? No? Okay. We'll proceed with testimony. The chair calls Mike Ware. And just so we get it ingrained into everybody's brain, your name, whom you represent if it's someone other than yourself, and your position on the bill. Mike,
morning.
you're gonna let everybody, you're gonna be the example, show everybody how to do this clearly, concisely,
I'll try not to miss it.
efficiently. All the pressure's on you. Ready to go.
Thank you. My name is Mike Ware. I'm the Executive Director of the Innocence Project of Texas, testifying for the bill. The best way I know to explain the importance of the bill is through cite examples that we've had. And, of course, there's Michael Morton. There's others. But more recently, less than 2 years ago, a client of ours, Lydell Grant, was exonerated out of Harris County. It was an extraordinary situation. He was convicted by 6 mistaken eyewitnesses who came to court and testified under oath that there was no doubt in their mind that Mr. Grant was the man they saw beat and stab a man to death in front of a bar in the Montrose area of Houston at about midnight one night. There was DNA under the victim's fingernails. And in this kind of case, this hand-to-hand wrestling beat stabbing case, DNA under the fingernails is extremely important. And we wanted to have it tested. And fortunately, Harris County agreed to testing. But if we'd have had to go through Chapter 64 and had to convince a judge that simply because Lydell Grant was excluded from the DNA under this victim's fingernails, then he should get he should at least get a test to prove that he could be excluded under the fingernails. The judge could very well say, I don't care if he's excluded under the fingernails or not. 6 eyewitnesses say he did it. That could be anybody's DNA under his fingernails. So we did get a test. We found it was a mixture of 2 people, 2 males, one being the victim, the other being someone not Lydell Grant. And we were able to upload that other DNA profile unknown male into the CODIS database, and it came back to the actual perpetrator, a man with the last name Carter, a man who fit the description that the original eyewitnesses gave, a man who was from Houston but who had fled Houston shortly after this murder, a man who had a violent history and had been arrested at almost at the very spot where this murder took place about a month before, and a man who had gone to Georgia, Atlanta, Georgia after this, and stabbed somebody else. So this is a public safety issue as well. If you've got the wrong guy, as Mr. Grant not only didn't do it, he wouldn't have done it, then this is a tool by which DNA testing can be had, and innocent people can be exonerated, and guilty people can be found and made accountable. Any questions?
Members who have questions for Mr. Ware? And I should have done this when you first came up. I want to extend my condolences on the loss of Jeff Blackburn. I know that your history goes back quite a ways with Jeff, and committed his life to a lot of the work you're talking about. Lost him a few weeks ago. Guys, if you have not heard of Jeff Blackburn, you should do yourself a favor and look him up. I'll leave you with a quote from the Texas Lawyer magazine, which called him the troublemaking lawyer in all of West Texas.
Thank you, Mr. Chairman. I couldn't have said it better myself.
So do yourself a favor and learn about him. I got to sit with him a couple times when I was at law school in Lubbock and got to hear some very interesting stories, probably some that are not fit for the committee room, but is a fantastic person and an advocate, and I know that was a very close friend of yours.
Thank you very much.
Thank you, Mike. Chair calls Benjamin Wolf.
Good morning again. My name is Benjamin Wolf. I'm the Director of the Office of Capital and Forensic Writs. I'm testifying on this bill. Just to dovetail briefly off of what Mr. Ware said, we have a very similar case involving the untested DNA that we wouldn't, under the current law, we wouldn't have been able to test were it not for the consent of the district attorney. And in that case, tested, it pointed to the culpability of a third party. It was uploaded into CODIS and obtained the results pointing to someone else. I'd suggest for the committee's consideration that the interest of reliability in the criminal justice system would perhaps be served by not relying on the consent of prosecutors to test third-party DNA and establish third-party guilt. Thank you.
Thank you, Mr. Wolf. Any questions?
I actually don't have a question. I just wanted to make a comment on this bill and why it's important.
Representative Jones has joined us.
Now?
Yeah, go for it.
So I'm a criminal defense lawyer. This is my 28th year and had a lot to do with DNA testing. I actually testified a long time ago on criminal justice about the importance of DNA testing and how it can identify who does whatever. And I was instrumental in helping shut down the DNA crime lab with HPD because they, at that time, didn't know what they were doing. People think that eyewitness testimony is reliable. It's not a lot of times because people are traumatized and they think they see things that they don't see. And they can honestly, from the depths of their soul, believe somebody did something that didn't. But people believe that it's reliable. Interestingly, I talk about when you lock up the wrong person, when you lock up an innocent person, the guilty are free to roam and commit more crimes. And I'll send to you, I didn't know I was going to be talking about this, but I'll send to you an ABC investigative report where specifically related to DNA testing in Houston, where a lot of women were raped and murdered because simply DNA was not tested. And had the DNA been tested timely, then a lot of crimes would have been prevented because they would have locked up the right person. But I also see some DAs just don't want to admit that they made a mistake. They will dig their heels in and they will keep a person locked up because they don't want to admit that they made a mistake. And so I think that this bill would go a long way towards getting subjective things out of the way and allowing justice to prevail. And sometimes when you test the DNA, it'll come back and inculpate the person. So people are presuming that it's going to exculpate people, but sometimes it inculpates people. So I think it's very important whenever it comes time for me to vote for it, I'm absolutely voting for it. And also what you don't understand is with people who are convicted in the criminal justice system, a lot of them do not trust court-appointed lawyers. They don't trust the system, and they believe that people don't have their best interests, so they will do a writ themselves. And like Rep. Thompson said, they don't know the law, they're not lawyers. I mean, I don't know too many jailhouse lawyers that are actually lawyers, but, and so they end up hurting themselves. And they're not trying to do it on purpose. They think they know the law. So I believe it's a very good bill. As I said before, I will be voting on it because I get Michael Morton discovery all the time. That was actually very good law, whoever passed it, thank you, Jesus. But, and related to Rep. Thompson's previous bill, I'll be voting for that as well. Thank you very much.
Thank you, Representative Jones. Good reminder that for our new members, any committee that is something of interest, you can always participate. You can weigh in. Also, a good reminder that we have subject matter experts that are our colleagues, right? People that have been both prosecutors and criminal defense attorneys. You have questions about these things. These are things to pick their brain about as you learn a little bit more about the policy arena. So, is anybody else wishing to testify on, for, or against HB 270 at this time? Chair sees none. The chair recognizes Dean Thompson to close on her bill.
Mr. Chairman, members, thank you for letting me bring this bill to this committee. Last session of the legislature, this committee voted this bill out 7-0, and the House voted out 145-1. Thank you.
Did you twist the arm of the one yet? You'll get there. This is another bill, members, I'd like you to think deeply about as we sit here. If there is no objection at this time, House Bill 270 will be left pending. If there's no objection, chair hears none. We'll leave HB 270 pending at this time. Chair lays out HB 286 and recognizes Dean Thompson to explain the bill.
Mr. Chairman and members, individuals with an intellectual disability are a vulnerable population, particularly in the criminal justice system where they experience disproportionate outcomes. In 2002, the United States Supreme Court ruled that executing people with intellectual disabilities is unconstitutional, but states were left to come up with their own ways to implement this prohibition.
Oh,
I'm sorry.
sorry, Dean Thompson. Yeah.
I apologize.
No, we're going to get to that one
Yep.
next. This is HB 286.
I apologize, Mr. Chairman.
No problem. I like both of them.
Yes, sir, me too. Mr. Chairman, members, I apologize. This bill involves a writ of habeas corpus, provides an avenue for overturning convictions based on constitutional violations or newly discovered evidence of innocence. House Bill 286 would create a ground for relief based on new, non-scientific evidence discovered after conviction. In 2013, the Texas legislature created a ground for relief under state habeas for newly discovered scientific evidence of innocence. This bill replicates that law for new non-scientific evidence, which can be just as powerful. Current law provides a way to present this type of evidence, but it is extremely difficult. The Texas Court of Criminal Appeals has ruled that for a conviction to be overruled, newly discovered non-scientific evidence must meet the highest legal standard, clear and convincing evidence that unquestionably establishes actual innocence. The court noted that it is a Herculean task to meet this burden of proof. Let me give you some examples. If a person is convicted of murder and years later the actual perpetrator confesses, it could be argued that the real perpetrator is lying because he or she is already in prison and has nothing to lose. Or video of a store robbery emerges after trial that does not clearly show the perpetrator's face, but casts serious doubt that the person who was convicted committed the offense. Mr. Chairman and members, I'm available for questions should you have any. If not, I would like to reserve the right to close.
Members, do you have any questions for Dean Thompson on this bill? Okay. If there are no questions, we'll proceed to testimony. Chair calls Mike Ware. Go ahead when you're ready, Mike.
Thank you. I'm Mike Ware, testifying for the bill. I'm the executive director of the Innocence Project of Texas. We are for this bill. We're located in Fort Worth, Texas. So we have a lot of cases where there is good evidence, material evidence, evidence that establishes by a preponderance of the evidence, makes it more likely than not that someone is innocent, that they didn't do this. But there is an issue with the Court of Criminal Appeals standard for meeting actual innocence. They have set clear and convincing, not quite as high as beyond a reasonable doubt, but much higher than the preponderance of the evidence. Clear and convincing, as they often use the word Herculean, and when you see that in the opinion coming back, Herculean, you know what's coming, that you didn't meet this Herculean burden, even though it's more likely than not they're innocent. It's not by clear and convincing evidence that they're innocent. This would fix that. It still has the material evidence. It still has to establish by preponderance of the evidence, and a judge still has to find, and the Court of Criminal Appeals still has to find that that's the case. Quick example, we had a case in San Antonio a few years back that got a lot of publicity, the San Antonio Four. They're now exonerated for a crime that never even happened. And of course, in the writ process, the first thing you have to do is file a motion or the writ in the court of conviction, the original court of conviction, and have an evidentiary hearing, ideally. And then the original judge makes a recommendation. Here's the evidence, makes a recommendation to the Court of Criminal Appeals, and ultimately the 9 judges on the Court of Criminal Appeals decide. When the San Antonio Four, even though we believed we presented overwhelming evidence of innocence, the trial court, in good judge, but the trial court said, I think you met it by a preponderance, but you didn't quite meet this Herculean burden. You didn't quite meet clear and convincing evidence with this. And therefore, I'm not going to exonerate the 4. Fortunately, the Court of Criminal Appeals saw it differently. And they said clearly they did meet their burden. But it could have gone the other way. And thank goodness it didn't. To my knowledge, that's the only case that exists in Texas where the trial court recommended against and the Court of Criminal Appeals actually overrode it in favor of actual innocence. So this is a bill that I think would result in those kinds of cases, a judge at least having the tools to see that justice is done.
Thank you, Mike. Do you have any questions for Mike? Members? Yes, Representative Bojani.
Just wonder, do you have an example of non-scientific evidence that you'd be to share?
Sure. A third-party confession. And, well, for example, in the Lydell Grant case that I mentioned prior, what I didn't say is that once this guy Carter was identified out in Atlanta and was under arrest, the Houston Cold Case Unit flew out to Atlanta, interviewed him, and within a very short time had given a full confession on tape that he is the one that committed this murder. What if that's all we had? You know, a court may have found, well, that's not enough to meet this high burden of proof. So a third-party confession, maybe a video that materialized later that shows that sure doesn't look like that guy. You know, and a judge, once again, that might not be enough to even to meet a preponderance, but at least a judge would have the discretion, and the Court of Criminal Appeals ultimately to have the discretion to grant relief in a case like that. Or witness recantations, you know. An eyewitness who later said, you know, I was really coerced into picking that person. That would be another example of non-scientific evidence.
Yes, Representative.
I can remember a case I had where we didn't even know that false testimony was going to happen, right? Read the offense report. It said what it said. I was absolutely prepared to cross-examine on what the officer said. Well, during this hearing, the officer just started making up stuff that I hadn't heard, right? So it's really hard to go investigate. I mean, at least if I have the offense report in advance, I can go investigate it. But this is happening at a hearing, right? So thankfully, the person, actually was an officer, a specialty officer in HPD, basically made up some stuff about a witness. We knew, myself and my co-counsel knew where the witness was. The witness happened to have been in Dallas. So, again, by the grace of God, we were representing separate defendants. As I continued to have the officer on the stand when he was just making up stuff that made it easier to convict our clients, he went to call the witness in Dallas who was being lied on. When he talks, this is the other lawyer, when he talks to the witness in Dallas is like, nah, that never happened, blah, blah, blah. But we couldn't get the witness to Houston because we only found out that the lie was going to happen during the hearing. That stuff happens all the time, where you learn new stuff during trial. It should have been presented before trial, and it wasn't. And then you're stuck with a conviction. And that's merely, I guess the good thing about it is after the judge and the prosecutor were made aware of this false testimony, they ended up throwing the case out. But I wonder what would have happened if I had been the only lawyer. This testimony comes in, the judge makes a ruling, and then I go call the witness later and find out. So it happens more than you think. And the one thing I've learned about it being a criminal defense lawyer for 28 years, or I'm in my 28th year, is that it seems to me that with the Court of Criminal Appeals, the law is just designed for them to protect the integrity of convictions, regardless of what's true or what's not true. And I will just remind us that in a death penalty case years ago, a lawyer was sleeping. The Court of Criminal Appeals said that having a sleeping lawyer was okay in a criminal case. So this guy got convicted in a death penalty case, and this lawyer was sleeping, and they came back and were like, well, you got to make sure that when the lawyer was sleeping, that it was testimony that was like really important to the conviction. When you think about that, how is a defendant, you're charged, let's say you're charged with a crime, how do you know what is important? You're just a person who's not a lawyer, and how can you prove that the part that the lawyer was sleeping in was what got you convicted? So I'm very excited actually to be sitting here listening to these types of laws, which I think will correct laws that are designed to preserve the integrity of convictions and not designed to find the truth of what happened and find justice for whomever.
Thank you very much. Members, do we have questions? Questions? No? All right. Thank you, Mike.
Thank you.
Chair calls Joanne Cothran. And I apologize if I mispronounce that. Cothran.
Kind of like Catherine. Cothran. Okay, my name is Joanne Cothran, and I'm a retired social worker, and I'm pleased to be here.
Okay, are you testifying for, on, or against House Bill 286?
Actually, I just had to pick one to do a witnessy thing, so is it okay if I leave these with you? I didn't know how to.
I have you listed here as for the bill. Is that accurate? In support of the bill.
Was that the one with the I read all of them.
This
All
is
of the
House
bills,
Bill.
but-
This is House
yes.
Bill 286.
Yes,
That I
about
have
the
you
habeas
read.
cor-
I have you
corpus.
registered as in support of the bill. Is that
Yes.
accurate?
Yes.
Okay. All right. Great. Just want to make sure that was clear.
Okay.
And hold on. Let me start this up. There we go. Please proceed.
Okay. My name is Joanne Cothran. I'm a retired social worker from Oklahoma. And I also have done homeless ministry. I went to Al-Anon for 10 years. I was a spouse of an alcoholic, and I have 4 children. I did 12-step groups at the Salvation Army, and I subbed for the last 7 years after I retired. I was very concerned when my 15-year-old got into a fight, one of my 4 sons, and I found out that it was a felony, that it was considered assault and battery, and that he could go to juvie. All my children are in AP classes, and today he is, member of society with children and family. Okay, so my biggest concern was when I was subbing that the children did not know that they would get a felony for fighting. They didn't understand if they were, they didn't understand their emotions, as I learned through my years of recovery with alcoholism. And I feel like this needs to be taught. The children are not being taught emotional health. Also, with the religious attitudes of children are accountable at the age 12 or age 8. As far as I was concerned, when my boys were 15 to 21, they were clinically insane. I mean, just the things that they did, their behaviors. They were in fraternities at Oklahoma State, and the emergency room knew them all by first name. I'm not saying that what my children were doing was okay, but going into the schools and subbing with teenagers, they don't understand the seriousness of getting into fights, and we're not teaching them how to de-escalate. We're not teaching them. So this is what I suggest. I also wrote my own sex education. I don't understand why we're not teaching that to the children because they're very confused. I wrote my own curriculum. I also have a paper, MANT training, Alateen, discussion groups, de-escalation, self-defense, and boundaries. These are things that you could do in 30 minutes in the schools and prepare the children much better for their emotional health, and et cetera. Thank you.
Chair calls Benjamin Wolf. And I do know we have one witness that is registering as we speak. So, Mr. Wolf.
Good morning again. My name is Benjamin Wolf. I'm the Director of the Office of Capital Forensic Writs, and I'm testifying on this bill. I was prepared to give many of the same examples as Mike Ware gave, and so I won't repeat those, but I'll offer one more. This bill would protect wrongfully convicted from poor lawyering. Many of you are lawyers and are familiar with the case Brady versus Maryland, which requires the prosecution to disclose exculpatory evidence. Often, what sometimes happens is that exculpatory evidence is disclosed, and then it's at the bottom of a box. And so this exculpatory evidence was never considered, never used, and the lawyer, for any number of reasons, may not have seen it, may not have understood its significance, but it wasn't suppressed, so it wouldn't make out a Brady claim. But this bill would enable persons in that position to present that sort of evidence. Thank you.
Mr. Wolf, thank you so much. Members, do we have questions? Mr. Wolf at this time? No? Thank you, sir. Like I said, I know that we have a witness that just ran back to register quickly, so we'll just wait for that to pop up. Chair calls Anthony Graves. I haven't seen him in a while. Mr. Graves, welcome back. Good to have you. If you could, for us, before you testify on House Bill 286, state your name, whom you represent, if someone other than yourself, and your position on the bill.
Thank you, Chairman. My name is Anthony Graves. I am the Director of Community Outreach for the Harris County Public Defender's Office. I represent the Innocent Project as well, and I'm an exoneree. And I come to testify on this bill because this is personal for me. I came because I sit back there behind bars, and I watch guys who had once filed an appeal. Evidence came afterwards, but we killed them because of a technicality. We wouldn't allow them to put the evidence forward because it didn't meet a certain standard. But we're talking life and death here. We're using technicalities to kill our people, our citizens. If there's evidence that come forward, why would we not want to review it? Because at the end of the day, if we get it wrong, we can't undo that. It's finality. They're not going nowhere. You have them incarcerated. Why not take the necessary steps to make sure that it is the right person and that they have had their day in court? I was down there where many people were represented by inexperienced attorneys. They didn't get their full day in court. There was issues that came up after they filed appeals. There were issues that came up years later. But the court rejected them on a technicality, said they had already had their one bite of the apple. We executed most of them. I don't know if they was innocent or not, but I know they had legitimate claims that should have allowed them back in court to explore more. But a technicality denied them, and we killed them. And I just want to come here and put a face on that because I was one of those people that you denied me for so long through the state system. I didn't get relief till I went to the federal courts. The state court, the very state that I worked, paid taxes in, denied me on a technicality and tried to kill me twice. I'm asking you guys to do something about that. There are men back there who need relief, but because of technicalities, they cannot get it. And you're gonna kill them. And you're gonna say it's okay. It's not okay. Not for their mother, not for their son, not for their father, not for the neighbor next door, not for their community. It's not okay. And it's not gonna be okay for you. I always tell people that what you believe in, make sure that you believe in it for you and your children as well. Because just because you believe in it doesn't exempt you or your family. I watched too many men, too many families come down there who once believed in the death penalty but found themselves visiting their son. And they didn't believe anymore. So I just say when we believe things and when we try to stop things on technicality, we always thinking about someone else's child. Start thinking about your own. And I tell you, you'll come to a different result. Thank you so much.
Mr. Graves, thank you. I appreciate that. I do, just for clarity in the registration, I know that you do work with the Innocence Project. I have you registered representing yourself here today on this bill. Just for
I'm
clarification.
representing myself.
Perfect. That's fantastic. Members, I want to encourage you, if you've never met Mr. Graves or had a chance to speak with him, to connect with him and learn more about his story. And how close did you come to?
I was just 2 months out. I was blessed. I was 2 months out. They were moving too fast on me, so I was able to slow the train down. I hadn't even went through my appeal process before they was trying to execute me. So that my saving grace.
I think you perfectly stated it, that there are a lot of individuals, unfortunately, that we've met throughout the time in this committee that put a face to the problems that we have when it comes to capital punishment. You are certainly one of those, and I appreciate you lifting your voice into this conversation.
Thank you.
Thank you so much, sir. All right, is there anyone else wishing to testify on, for, or against House Bill 286? If not, the chair recognizes Dean Thompson to close on her bill.
Mr. Chairman and members, for those who are new, I want to let you know that this bill came out unanimously from the committee, and it got a vote on the House floor, 143 to 0. I close, Mr. Chairman.
Thank you, Dean Thompson. If there's no objection, well, actually, let me back up. This is another bill I'd like you to think about. Based on the numbers that Dean Thompson just stated to you. If there's no objection, HB 286 will be left pending. Is there objection? Chair hears none, and the bill is left pending. Chair lays out House Bill 381 and recognizes Dean Thompson to explain the bill.
Mr. Chairman, members, thank you again. Individuals with an intellectual disability are a vulnerable population, particularly in the criminal justice system, where they experience disproportionate outcomes. In 2002, the United States Court of ruled that executing people with intellectual disability is unconstitutional, but states were left to come up with their own ways to implement this prohibition. The United States Supreme Court twice said in March of 2017 and in February of 2019 that Texas test for intellectual disability is unconstitutional, as it has been using obsolete medical standards for determining whether those convictions of capital offenses are exempt from the death penalty because of an intellectual disability. Today, there is no state law regulating how or when a court determines that a capital defendant has an intellectual disability, so courts have decided their own approach. This has created a huge disparity in how these determinations are made across the state. Current practice does not prohibit individuals with an intellectual disability, and it's clear that the courts of criminal appeals need directions. This bill prohibits the death penalty for an individual with an intellectual disability, codifying the United States Supreme Court's holding in Atkins versus Virginia and the Moore's decision in 2017 and 2019, where we spend millions and millions of dollars trying to go backwards and forth. I think over $30 million just going to the court on this very issue. It requires an evidentiary hearing before a jury prior to trial to decide whether a defendant is intellectually disabled based on current medical standards. If a defendant is intellectually disabled, the defendant is tried for capital murder and may be sentenced for life without parole. Trial lasts around a week. If a defendant is not intellectually disabled, the defendant is tried before a death penalty qualified jury and may be sentenced to death. And this trial lasts about a couple of months. If you remember, those of you who may have been part of this committee last session, the district attorney from Tarrant County wanted the opportunity and Smith County wanted the opportunities for jury determination. So we added that in the bill, Representative, this time. So, Mr. Chairman, I would like to reserve the right to close. I'm available for questions if there are any on this particular bill. What we're trying to do is, we believe that if we have a pretrial hearing on this one, we can make that determination up front. We're going to be able to save the counties about $2 million rather than going through the whole trial and then at the end we make this determination. If the person is not intellectually disabled, we go to the capital murder trial. If they are intellectually disabled, we do the pretrial hearing and we make a determination up front, and we save two things. We save the county time, Judge Phillips, and we save the county and the taxpayers who's footing this bill, we save them money. I like to reserve the right to close, but I am available for questions should this wonderful committee have any questions to ask me about this bill.
If there's no questions, do we have questions? Representative Schatzline.
So could you help me understand just kind of the scope of intellectual disability? This is something that we're trying to work through, and forgive me, and just trying to understand what that would apply to, even just understanding that term specifically, because it wouldn't be learning disability, it wouldn't be something like that. This would be something far greater, correct?
Well, I'm going to do this for you. I'm going to ask Representative Jones, who have had this experience recently, to explain that.
We also do have a witness that I think could weigh in on that particular question if we want to do that. Okay. However you want, Dean Thompson.
If she would be brief.
Yes, I'll recognize
So-
Representative Jones.
It's really interesting. So I'm actually going to use an example. It's not a capital case, but how if someone has an intellectual disability, why are you killing them, right? There's been this video of this student who pushed his teacher and he started hitting her. People familiar, I think that happened last week. In a vacuum, it looks horrible what he did. Somebody ended up putting on the internet what happened after he did it. And the kid was like, am I going to jail? Like, he was so basic. I don't even know how to explain it because I don't want to explain it in legal terms. You could tell that that kid did not understand what he did. And I do not believe that this bill is saying let them go, right? This bill is saying, one, you have to have sufficient mens rea, sufficient mental state to know that what you did was wrong, right? This kid clearly had impulse controls. He got upset because they took a game away from him in class. Maybe he needs to be in an alternative school. Maybe he needs to be in a place for people who have intellectual challenges. And I'm not saying he should be put back out into society, right? But what I am saying is, I mean, the greatest punishment that this state can give to a person is to take their life. And we should only do that under circumstances where people appreciate what they've done. And I don't know if you ever grew up with somebody in your neighborhood who just was slow. I mean, people called them slow. They didn't understand what they were doing, and that's what we're talking about. And what that does is, by the time you appeal death penalty cases or even capital cases, you're spending millions and millions and millions and millions of dollars. This is going on for years and years and years and years and years. And I think before the state wastes money on that we need to make sure that whoever we decide to kill, that they understood what they did. But again, a lot of times in trials, you only have like that video where the kid threw his teacher and is hitting his teacher. You don't have the video where he's like, am I going to jail? You're like, okay, he doesn't understand what he did. It's terrible what happened. So now that we know that, and I believe that this is just a way to try to work all that out before you're convicted and before the state spends money rather than after, because as I said before.
I think that,
Thank you
Representative
very
Jones,
much.
I think that does crystallize it. I want to just comment real quick. This goes back quite a ways. There's the case law, the standard is you cannot execute someone who has an IDD. End of story. They left it up to the states how to do that. Twice, the United States Supreme Court, twice in the same case, the Bobby Moore case, Bobby Moore, who is now home with his family, said, Texas, you're not doing this correctly. There was tension between the legislature and the Court of Criminal Appeals. Court of Criminal Appeals said, give us a solution. Please answer the Atkins case. And we continuously, even though Dean Thompson's been filing this bill for years, continuously did not send a structure for making this determination. And so it's been kicked back and forth in the court system. This is the structure that allows science to guide the determination, and it allows for that determination to be made before the trial. To Representative Jones' point, let's determine that up front. Doesn't mean no accountability, it means no execution. And so we are commanded to figure this out, and we have abdicated our responsibility here by not passing this bill. Now in 2019, this went all the way to conference committee, and we couldn't quite solve it and get it to the governor's desk. This is a very important bill. When I chaired this committee last in 2017 is when the Bobby Moore case came down, the first time they slapped us down for a bad process. So this is one of those that's on, has been on my to-do list for quite some time. With that being said, I know we do have some witnesses that want to weigh in. I want to recognize that Representative Bowers has joined us now before we start witnesses. Let me call Kirk. Chair calls Kirk. Is it Noacker? Noacker. Yes, Mr. Harrison? We can come back around to it.
Thank you. I feel like I have the easiest job here today because we've already talked about this at great length before my coming up here. Chair Moody and committee members, my name is Kirk Noaker. I thank you for the opportunity to testify in support of HB 381. I've spent over 20 years in law enforcement. I was employed as a capital defense team member for the Regional Public Defender's Office in capital cases. I served as a county magistrate judge, and I currently serve on the Commission of Jail Standards Committee and the collaborative council member with the Judicial Commission on Mental Health. Today, I'm here testifying on behalf of the ARC of Texas. The ARC of Texas advocates on behalf of persons with intellectual and developmental disabilities. To start, it should be noticed that HB 381 codifies in Texas law what the United States Supreme Court has already decided 3 times. It aligns Texas law and procedures with the Supreme Court's mandates and establishes consistent standards across the state in the following ways. First, it defines who can evaluate and diagnose an individual with ID by creating uniform standards. We know that people with IDD are overrepresented in the criminal legal system. Although they are 1 to 3% of the general population, they make up 4 to 10% of our jails and prison population. Because those with IDD have unique characteristics, which may trap them in a chain of exploitation and make them susceptible to being used to commit or facilitate crimes, and unable to often assist in their own defense. Second, those characteristics I just referenced require communication and behavioral adjustments, which may not initially be evident to first responders and legal professionals. So they enter a system at higher rates and without necessary supports, and those gaps have yet to be fully addressed in policy. But this bill seeks to set precedent. Lastly, I'll conclude with a brief history on the death penalty and ID. In 2002, the United States Supreme Court said that sentencing someone with ID to death violates the 8th Amendment because it inflicts cruel and unusual punishment on persons who, as the Atkins ruling states, as you referenced, sir, as the Atkins ruling states, do not act with the level of moral culpability that characterizes the most serious adult criminal conduct. As recently as 2019, the United States Supreme Court issued the second of 2 rulings regarding Bobby Moore, stating that Texas's standard for identifying ID in capital punishment cases was and remains outdated and not based on science. We're not debating whether we can put someone with ID to death. In fact, the United States Supreme Court has already decided that 3 times. Rather, this bill establishes a process for Texas courts to make those assessments, which saves the state time and money. I welcome any questions.
Members, do we have questions? Thank you very much.
Thank you.
Chair calls Jennifer Alman.
Thank you. My name is Jennifer Allman, and I'm the Executive Director of a Texas Catholic Conference of Bishops, who I'm representing today, and I'm testifying in support of House Bill 381. Chair Moody, you laid it out perfectly, so I don't need to repeat a lot of what's already been said, but I want to point out a couple of points that we haven't discussed. Dean Thompson mentioned that this saves time and money. The previous witness mentioned that this saves time and money, but the other really important thing that this saves is grief and pain for the families involved in this process, whether it's the victim's family or the accused's family. To have to go through this process, Bobby Moore's family had to go through that time and time again. Doing it pre-trial gives a level of certainty in advance, and that helps families deal with the process. We've talked about moral culpability and the level of culpability of a person with an intellectual disability. It's important to point out that persons with an intellectual disability only represent 2 to 3% of the overall population, yet they represent 11% of the incarcerated population. This is not because they're more criminally inclined. It's because they lack the cognitive ability to defend themselves and the ability to reason and make these decisions. And so they get caught more often. And then once they're caught, they're not as equipped to engage in their defense. And so it's important that we protect this vulnerable population. And this bill outlines a process for doing that, which we have been directed to do by the courts. So I applaud you for looking at this issue, especially Representative Thompson for her perseverance in bringing it to the committee over and over and over again, the committee voting for it over and over and over again. And we hope this is the time it gets done. So thank you for your time and effort on this important issue.
Thank you, Jennifer. Members have questions. Jennifer? We're good? Chair calls Raul Schoenman.
Good morning, Chairman Moody and distinguished members of the committee. My name is Raul Schoeneman. I'm a clinical professor at the University of Texas School of Law and the co-director of the Capital Punishment Clinic. I've been an attorney for 30 years and on the faculty of the law school for the past 10 years, and I'm testifying today on the bill. Before I get to I've submitted some written testimony that's fairly lengthy. I'm not going to read it to the committee. I'm going to just sort of hit the main points, but I wanted to address a question that was raised by Representative Schatzline about who does this bill apply to. The intellectual disability test, the first prong of it is significant sub-average intellectual functioning as measured on a standardized measurement of intellectual functioning, an IQ test. And significant sub-average intellectual functioning is 2 standard deviations from the mean. And the way mathematics, I looked this up on Wiki right before I came up here, defines that as 95% of the population would be within 2 standard deviations of the mean. So if you think of a bell curve, you've got 95% of the population within that, and then you've got 2.5% at the bottom and 2.5% at the top. So we're talking about the bottom 2.5 percentile of the population as measured on a test instrument of that kind. I want to address I have 3 points to make. The first is the need for this legislation. The Supreme Court protected the class of intellectually disabled persons 2 decades ago. 12 years later, the Court of Criminal Appeals, in a published opinion, did something that's relatively unusual. I can't think of any other occasion when this has happened. Issued a published opinion calling on the legislature to enact a statutory procedure for determination of intellectual disability prior to trial. I'm just going to read 2 sentences from that opinion. They said, while we withhold normative judgment, the need for a statutory scheme on this score is readily apparent, and its continued absence portends serious consequences for our criminal justice system. There's an ellipsis, and then they go on to say, we now make explicit what we before expressed only tacitly, legislation is required. So here we are 7 years later, we are still possibly the only state that has the death penalty that has yet to enact a statutory scheme for this purpose. As a result of no statutory scheme, the courts have been left to fashion their own procedures. And that has resulted, particularly when this has been left up to individual trial judges, to a chaotic array of varying procedures, which is really the unacceptable way of determining whether somebody is constitutionally exempt from a capital trial and a death sentence. The prevailing procedure that is employed today is to submit the question of intellectual disability to the trial jury at the end of the trial at the penalty phase, after the jury has heard and convicted the defendant of the crime and heard the evidence of penalty. It's my opinion, I realize I'm out of time, that's not a constitutional way of doing this. And I explained the reasons for that in my written testimony. And that is, the Supreme Court made very clear, and Representative Thompson remarked on this in her opening remarks, that the reason that the court said that this class is protected is because they're particularly vulnerable and susceptible to wrongful conviction and wrongful imposition of the death penalty. That is, they're not only exempt from a death sentence, but they're exempt from the proceedings in which a death sentence is sought. So this is a pretrial determination. It follows, to my mind, as a necessary logical conclusion from the rationale for protecting the class that the determination has to be made before trial and not in trial. We are one of the only states that does that. And so the only other point I make in my written testimony is about the interest in fiscal economy and judicial economy and having the determination made before a very expensive capital trial is conducted. Some of the other witnesses have already addressed that. Thank you very much.
Thank you, Professor. Do we have follow-up? Yes, Representative Harrison.
Thank you, Chairman. Thank you. Just real quick, and you may have partially answered the question I was going to ask, which is given that states were granted latitude by the Supreme Court to adjudicate their own means for enforcement of this constitutional prohibition of the execution of individuals with IDD. Did I hear you correctly that 49 states have acted on that?
Well, not all 49 states have the death penalty. I think it's
of the ones that have the death penalty, how many do have?
How many have statutory procedures?
Correct.
There is I have this in testimony I submitted to the committee last session and took it out of this. So and I haven't updated my data.
Just roughly.
I think we were down to like the last 3 states without a statutory procedure.
Okay.
Okay, so most states have enacted statutes to do this. There are some judicial opinions that have laid out the procedures. Texas Court of Criminal Appeals has issued opinions to that effect, but there are still ambiguities about the procedure that have to be resolved at the trial level. And I still think there's a need for a statutory scheme that's consistently applied in every case. And again, as I say, Representative Harrison, I think the primary defect of the prevailing practice is that the determination is made in the trial, at the end of the trial. The whole rationale for protecting this class is to protect them from a proceeding in which they could be sentenced to death because they are particularly susceptible to wrongful conviction and wrongful sentence of death.
Sure. And then just final question. Of the states that do already have statutory procedures, as you've outlined, do you know if this proposed definition of intellectual disability is consistent or more broad or more narrowly fashioned than how other states have defined it?
The definition in this bill, I think, is consistent with the Supreme Court's definition.
Thank you very much.
Yeah.
Thank you, Chairman.
Thank you.
Thank you. Members, we good? Professor, thank you. Chair calls Benjamin Wolf.
Good morning again. My name is Benjamin Wolf. I'm the director of the Office of Capital and Forensic Writs, and I'm testifying on this bill. I'd like to make two broad points. First, to follow up on the points that Professor Schoenman made about the existing chaos of the present system and what the Court of Criminal Appeals and its published decision asking for legislative action called serious consequences. Our office recently handled a case where most of the cases that we handle are capital cases, are new cases. Shortly after a death sentence has been rendered, but we handle a handful of later stage cases. 2 weeks ago, and we were appointed to represent this particular individual who's been on death row for 15 years, and and were appointed somewhat recently. He had 3 prior execution dates set, and 2 weeks ago, the Attorney General, the local elected district attorney, and the trial judge agreed that he was intellectually disabled. And so I think that that's a reflection of, in the absence of a statutory system, the chaos that results, the unpredictability that results. And so sometimes people are found intellectually disabled at trial. Sometimes they're found intellectually disabled on post-convictions, and sometimes not at all. And it's entirely unpredictable. The second point I'd like to make is one of cost. There's, I think, Dean Thompson referenced Smith County in her remarks. The last death penalty trial in Smith County, I know this because we have the auditor's records, cost $1.2 million. And it's fair to say that modern death penalty trials fairly and easily cost $1 million. And so I think that I would submit that there is an interest in diverting this class of people against whom this punishment cannot be constitutionally imposed early on in the process before these costs get incurred. There are estimates that from the ABA and other sources that death penalty cases, generally speaking, including increased costs of incarceration, cost 2.5 to 5 times more than non-capital cases. Trials or death penalty cases might cost between $2.5 and $3 million, far more than other trials. Thank you.
Thank you, Mr. Wolf. Do we have questions? No? Thank you. Is there anyone else who wishes to testify on, for, or against House Bill 381? If not, Chair recognizes Dean Thompson to close on the bill.
Thank you, Mr. Chairman. Members, this is a bill that also has come out of this committee as well. Members, each death penalty case in Texas costs taxpayers millions of dollars and we've heard that from the testimony here today. The procedure in this bill will save time, money, protect the state's interests, and it would ensure that we are consistent with constitutional standards. There is no reason why, in my opinion, that Texas should continue to spend time, money, or violate persons' constitutional rights when we have all of this bill, and we have 19 death penalty states that requires or provide for pre-trial determinations on IDD capital cases. Mr. Chairman, members, thank you very much, and I'm looking forward to favorable consideration. Thank you.
Thank you, Dean Thompson. I appreciate that. Worth noting that in 2019, your joint author was Chairman Jeff Leach, just in case anybody wondered.
And I want him to know that the door is wide open for him to be the joint author again.
I bet he'll take you up on that. This is one, members, that I will ask you to give some deep thought to over the next bit of time here.
Oh, and I even picked up Representative Cook. Moving on up.
If there is no objection, HB 381 will be left pending. Is there objection? Chair hears none, and HB 381 is left pending at this time. Chair lays out HB 513 and recognizes Chairman Metcalf to explain his bill.
Good morning. Thank you, Mr. Chairman, members. It's good to be with you all. And I can't help but say, hopefully you'll give this one some deep thought as well for today. Why stop now, right? No, in all seriousness, thank you all for having me this morning. Unfortunately, we all know the dangers of fentanyl and the drastic effects it has had on our state. According to Texas Health and Human Services, 1 in 4 Texans have experienced an opioid overdose or have known someone who has. Texas DSHS estimates that there were over 2,500 opioid-related overdoses deaths in 2021. In my very own home county of Montgomery County, fentanyl-related overdose deaths have shot up 271% between the years 2019 and 2021. We've seen drug traffickers make a deliberate effort to target children and young people with rainbow fentanyl, disguised to look like candy. Fentanyl is an opioid that is 50 times stronger than heroin and may be mixed with other substances and counterfeit pills. Even in doses as small as 2 milligrams, fentanyl can cause a life-threatening overdose or be lethal. We need to give our district attorneys the tools they need to combat the individuals preying on our citizens. That is why I filed House Bill 513 to provide the creation of a standalone offense for someone who distributes drugs that cause an overdose. Under current law, the pathway to hold accountable those who manufacture or deliver a substance causing death is tied to the weight of that controlled substance. This can be problematic in practice because investigators are generally only going to be left with whatever amount was not used, if any at all. In most cases, a victim will use all of the drugs. This ties the hands of the officials investigating and prosecuting these crimes. House Bill 513 will create a standalone offense for the manufacturer or the delivery of a controlled substance causing death or serious bodily injury that allows for an appropriate punishment range. This enables law enforcement and district attorneys to hold offenders accountable. Mr. Chairman, members, thank you for having me. I do have some star witnesses available to testify.
Chairman, thank you very much. Do you have any questions for Chairman Metcalf? I know also schedule-wise, if we need to close on your bill for you, we're happy to do that as well. No, we'll move on to testimony.
Thank you, Mr. Chairman.
Chair calls Jack Armstrong, the second. Just by way of reminder, need you to state your name, whom you represent, if someone other than yourself, and your position on the measure.
Yes, so I'd like to say thank you for letting me be here today. I'm Jack Armstrong. I'm the sergeant with the Montgomery County Narcotics Enforcement Team. And I'm here representing Montgomery County Sheriff's Office. And I'm here in support of this bill. Representative Metcalf took a lot of the words kind of right out of my mouth. So we started this endeavor in 2019 because we saw a significant uptick in overdoses. And what we're seeing a lot today is the fake pills that they're lacing with fentanyl. People think they're going and buying an Oxycontin or a Xanax or a Vicodin, and it's pressed in on the streets. You can order pill presses online, and they get the mix and the combining stuff, put a little bit of fentanyl in it, and they take that one pill, and it kills them, or kills it either puts the victims in a hospital or it kills the victim. And unfortunately, once they take that one pill or those two pills, there goes our evidence. And how the current law is written, we have to have a weight behind it. And this really cleans that up for us, and it helps us bring closure to the families. So I'll leave you with that, and if you have any questions of me, please feel free to ask.
Okay. Members, do you have any questions at this time? No? Thank you, sir. Appreciate your testimony. Chair calls Michael Uber. I'll continue to be repetitive. Please state your name, whom you represent if someone other than yourself, and your position on the bill. Thank you, sir.
Mr. Chairman, members of the committee, thank you for your time. My name is Michael Uber. I'm representing the Montgomery County Sheriff's Office, and I'm here to testify on behalf or in support of this bill.
Thank you.
I am just a street cop, and I wanted, you're going to hear from the district attorney, the sheriff. You just heard from my good sergeant. I wanted you to hear it from the guy on the street that's seeing us every day. As time goes by, laws, as we all know, need to keep up with the times. I think this bill is addressing that. The uptick in fentanyl overdoses that we've seen across the nation and now in this state and in my county have gone up dramatically. Due to the fact that fentanyl is so potent and the way it's being introduced, I think this new bill will help us combat that. There isn't hardly any measurable weight that we can set down on a typical drug scale and say, this much is enough to kill you. The dose to kill you is almost in micrograms. So being with the way the current law is, we're just not keeping up with it. We're also finding that as we get to these crimes with this current law that's in place, that we're required to have a weight to make those charges. We find that sometimes a family member finds the body prior to notifying us and or a friend that scene we're finding is being cleaned or sanitized prior to our arrival. So in that case, someone finds the drugs, they remove them from the scene. By the time we get there, we have no drugs. Or we have a death scene that we show up to where there's no obvious signs of narcotics use. We find out the following morning from our forensic center that they are testing positive for fentanyl. We've just lost our crime scene. So with that current law saying that we're required to have a weight, this new bill will help us combat that and help give the families of these grieving people some justice or some sort of closure. I thank you for your time. If you have any questions, I'd be willing to.
Thank you, Detective. I appreciate giving our committee kind of frontline understanding of what you're looking at. Do you have questions, members? No? Thank you, sir.
Sure. I thank you all for your time and your service.
Thank you. Chair calls Brett Ligon.
Good morning. How are y'all? My name is Brett Ligon. I'm the elected district attorney of Montgomery County, Texas. I'm here testifying on behalf of Bill 513. If I could take just a few moments. Mike Uber.
In support of, I have you.
I'm
here.
sorry.
Just make sure.
In support of Bill 513, Representative Metcalf's bill. And if I could.
Yes, sir. Please
and if I could, I want to say that Mike Uber is not just a patrol officer, not just a police officer. Mike Uber is a hero. Mike Uber, Mike Landrum, those guys over there with MocoNet, not only them, but also the men and women and EMTs that are out there actually trying to revive these people. And I kind of want to put a point to what Mike is trying to tell you. It's not just your community, it's not just my community, but it's the community of the state of Texas. We're being flooded with fentanyl. Take your kid, a good kid who's college bound, or a kid who wants to study for a college exam, and they're taking Adderall or Ritalin, right? And perhaps they have a prescription, perhaps they don't. We're not talking the fact that these people are on the corner trying to get drugs to get high. Oftentimes what we're seeing with our juveniles and our youngest, which is what part of this bill is aimed at, They're taking something that is a pressed pill. It's a fake pill, thinking they're getting Adderall from a buddy or from a person at the gym or Ritalin and helps of increasing their academic performance. Now, what Mike tells you about micrograms, I'm from Texas. I wouldn't know a microgram from an inch, right? But I can tell you this, that 2 pieces of salt is a fatal amount. Take a salt shaker out and those 2 grams this morning at lunch, right? You're going to see that. That's a fatal amount. Take the tip of this pencil of fentanyl. That is the fatal amount. What Uber was trying to tell you was the fact is oftentimes these people ingest it and we can determine that there was fentanyl in their system and that's what killed them, but we can't measure it. So this doesn't create new law, but specifically the statute that it's attached to is the law that deals with delivery to a child. A child is somebody under 18 years old. And what the statute seeks to do is make sure that if you kill a kid, not only in Montgomery County, but if you kill a kid from delivery, that you're facing a first-degree amount. It's a 5 to life. Because you should. When you take away the future of Texas, right, what do we have left? And these are people that are preying upon the youth of Texas. Not just Texas, but Texas is all that we can help right today. The second part that Representative Metcalf is trying to address is what happens if you're an adult on a delivery. Right now, what Uber's trying to tell you is, and I hope I'm not stealing the thunder of our great sheriff, Sheriff Henderson, but what he's going to tell you is oftentimes they're having to dig through garbage, they're having to dig through toilets to get the measured amount, to get the enhancements. What we're looking for is if you injure an adult, it's a third-degree felony, serious bodily injury, and if you kill an adult, somebody over 18, that it's a second-degree felony, trying to make that equal to the same as you would like an intox manslaughter. So all it is clarifying the penalty provision of the state law that's already in existence.
Mr. Ligon, thank you so much. I appreciate you spending time with us, and I want to make sure, we got the timer here, but I want to make sure that you've taken time away from the job out there in Montgomery County. Is there anything other than your testimony so far you'd like to make sure that you impress upon us on this bill?
No, I mean, it's a great bill. The laws are in existence. We're just seeking to enhance the punishments for it when you kill people with it or hurt them with it.
Yes, sir. I appreciate it. Thank you for the job you do.
Any questions for me?
Members?
Thank you.
They know better than to ask you a question. He gave you a good introduction, so we'll go with Chair will call Rand Henderson, Sheriff Rand Henderson.
Yes, sir, that was a great introduction.
Yeah, is everybody from Montgomery County here currently?
We brought some key folks. We did.
Don't tell the bad guys. They're all here.
Well, I've been watching Mr. Ware, so I'll see if I can get this right.
Thank you.
I'm Sheriff Rand Henderson of Montgomery County, Texas, which is suburban North Houston, the 12th most populous county in the state of Texas. And I'm here to testify for this bill. The guys that you heard from earlier have done a great job summing this up. They are speaking for the dead. The difference that we have taken a different worldview, and that for homicide offenses, it's normal to roll out homicide, violent crimes to go deal with those offenses. Well, we've changed that in conjunction with working with HIDA, which is the High Intensity Drug Trafficking Area, which is a program of ONDCP, the Office of National Drug Control Policy, along with my alma mater, Sam Houston State University. And we have come up with a program where we also roll narcotics investigators to these offenses, for just like Detective Huber spoke of, is trying to gather that evidence so it's not lost. This sounds like a normal concept, but it's actually very novel. So we're working to identify the narcotics if they're left there. So as was already spoken, you know, these kids, these adults, it runs the gamut, are being lied to by drug dealers. I know you find that shocking, but the drug dealers will tell them this is a Percocet, whatever drug this may be. Well, in reality, it's a pressed pill. It's something that has been created that has no of the effective ingredients of the drug that's being sold. And the drug dealers know this. We know this because in Montgomery County, we got a $3+ million opioid settlement, and our commissioner's court, led by Commissioner James Nowak, chose to divert that money to this project. So we're working toward education to prevent the taking of these drugs by those that don't know. One Pill Can Kill is a HIDA project. You may see the billboards around. But we've also taken that $3 million and we're going to invest that into prevention of overdoses and eradication of some of the some of the methodologies the drug dealers use. And then we also want to put these, those that make these drugs available in prison so they can't continue to harm our vulnerable population. And with that, I would be happy to answer any questions you may have.
Sheriff, thank you very much. I appreciate you taking time to be here and giving us your expert opinion. Members, do we have questions for the sheriff this time? No?
Absolute honor. Thank you.
All right, thank you, Sheriff. Chair calls, I have here M. Page Williams.
Good morning, Chair Moody,
Good morning.
committee members. My name is Paige Williams. I am representing Dallas County Criminal District Attorney John Crusoe, and we are in support of House Bill 513.
Thank you. Please proceed.
Thank you. I am not going to belabor everything that you've already heard, but I want to point out one thing. Fentanyl is not a bipartisan, fentanyl is a bipartisan issue. We are seeing it in Dallas. We're seeing it all over the state. It doesn't matter if we are rural, suburban, or urban. It is attacking our children, and House Bill 513 allows us to use tools that are already in place and just enhances them for prosecutors. These two changes in the law will allow us to go after illicit fentanyl dealers, and it doesn't matter if they are children dealers, as we have seen in Carrollton, where the 13-year-old passed away just a few weeks ago, or they are adult dealers dealing to children. It will cover dealers, and that is where we need to strike the most force. And if you have any questions, I'll be more than happy to answer them.
Members, do you have any questions for Ms. Williams? Representing the rest of the state of Texas outside of Montgomery County today, so. No? No? Thank you very much.
Thank you.
Appreciate it. All right. Is there anyone else wishing to testify on, for, or against House Bill 513? If not, the chair recognizes Chairman Metcalf to close on his bill.
Thank you, Mr. Chairman, members. If you don't have any other questions, I close.
Members, questions? Yes, Representative Harrison.
Hey, thank you, Chairman Metcalf and Chairman, and to the members of law enforcement that are here with us. There's obviously a massive problem statewide and nationally with opioids generally, but the scourge of fentanyl is particularly pernicious. So thank you for allowing us to debate some ways that we can help with that situation. One question just I had about the bill, because always concerned about potential unintended side effects of government action. If the way it's phrased here, whether the controlled substance or marijuana was used by itself or with another substance, could there be a potential instance where, let's say, because I agree, as the way I've heard every witness, we want to go after the fentanyl dealers, and I agree, like, strongly. What if there was an instance, because marijuana is specifically referenced here, let's say a hypothetical example where somebody was given, sold, whatever, otherwise distributed an extraordinarily small amount of marijuana, let's say less than an ounce, and then that was consumed by somebody who later on deceased. But let's say they consumed the marijuana 24 hours before they took whatever it was that actually was the proximate cause of their death. Would the person that distributed that very small amount of marijuana be a first-degree felon under the reading of this?
So I believe that is encompassed in the Controlled Substance Act, but I will, if I can get clarity, Mr. Chairman.
I was actually looking at that too. So that the short answer is no.
Okay.
Right.
And forgive me if that's an inartful way for me to phrase this question.
And the way it's right, the way it's broken out, controlled substance and marijuana is because they're treated different in the health and safety code. So that's why they're laid out there.
Yeah.
But it has to be tied to that conduct. So no, it's not going to be if you're not the actor that's also involved in how the fentanyl is that actually caused the damage. It needs to be tied together. So you're not going to capture somebody that is not really involved in doing the damage. And that's the way I read it. But we'll dig into it and make sure that's the case. But that's the way I read it, Chairman.
Extremely helpful. Thank you.
Thank you. With that I close. Thank you, members.
All right.
Chairman.
Thank you. If there's no objection, HB 513 will be left pending. Is there objection? The chair hears none. HB 513 is left pending at this time.
This is this Shaheen. 469. So we
He was going to have Shaheen go.
yeah, that's what I thought. Yeah, so it's this one. Yeah, I think that's where we're going. Yeah. The chair lays out HB 598 and recognizes Representative Shaheen to explain his bill.
Chair Cook, members, thank you for the opportunity to lay out House Bill 598, which makes it unlawful for an individual who has previously been convicted of animal abuse to possess an animal. The bill establishes a Class C misdemeanor for an individual who has previously been convicted of cruelty to non-livestock animals, dog or cockfighting, or attacking an assistance animal, and is found to be in possession of an animal. So, just to be clear, these are crimes where somebody has previously been convicted of torturing an animal, killing, maiming, poisoning. These are serious previous offenses that somebody has been convicted of. And so if you look at states like Hawaii, West Virginia, Rhode Island, several other states have similar legislation in place. There's a concern that current Texas law, which doesn't have any type of provision in place, isn't doing enough to protect animal abuse from individuals that show in their history to abuse animals. The only other thing I would offer, Mr. Chair, is that the bill does escalate to a Class B misdemeanor if it's a repeat offender. With that, I'm available to answer any questions and reserve the right to close.
Great, thank you, Mr. Shaheen. Members, any questions for Representative Shaheen? Representative Bojani.
So if somebody has been convicted in another state for doing the same thing, is that going to be also inserted
Yes,
with this?
It's if you've been convicted of this offense and it's on your record, then this applies.
Doesn't matter where it happened, if Texas or otherwise.
That's correct.
Thank you.
Members, any other questions? Mr. Harrison?
Yeah, thank you, Chairman. Thank you, Representative. How are we defining animal in the statute? Like,
It's already defined in statute. Animal is a domesticated living creature, including any stray or feral cat or dog, and a wild living creature previously captured.
so this wouldn't apply, like, for example, if somebody, let's say, committed one of these heinous acts, and they are heinous, 10 years ago, or as a young person, they get older, they want to farm, they want to ranch, they want to have cattle, they want to have a horse. Would it implicate their ability to do that?
And this only applies to non-livestock as well. But like, for example, I hit a deer last year, and this would not apply to me. And it did $10,000 of damage to my truck, by the way.
Oh, probably slightly more to the deer.
But no, this is an animal that's domesticated, and it's already defined in statute.
Okay, so they would not preclude somebody from owning a horse or owning a cow afterwards?
Now I want to be clear, if they violate, so if they've been convicted of cruelty to non-livestock, so non-livestock.
Right.
Animal assistance, if they've heard an animal used for assistance, dog or cockfighting, they can't own any type of animal.
Is there a time limitation on that, or is it for the rest of the?
There's not. I will tell you that when we looked at other state statutes, there were time limits.
Okay.
So I'm very open to that concept. I think most of the other, like I mentioned, Hawaii, West Virginia, there was a 5-year.
Okay.
limit, and I think that's probably
something you'd be open to.
Yeah.
Thank you, Representative Chairman.
Thank you, sir.
Thank you. Mr. Shaheen, just to clarify that you accidentally hit the deer, right?
Really, for the record, the deer hit me, but I won't go into detail.
Thank you, Mr. Shaheen.
Thank you, Mr. Chairman. Thank you, members.
Is there anyone here who wishes to testify on, for, or against House Bill 598? Hearing none, we'll leave. Oh, I'm sorry. Oh, we didn't have anybody registered.
Being deferential, I thought perhaps Chair Goldman was coming up to testify.
Did you register for HB 598? Because I don't have
I believe
anybody.
that's in process. My apologies.
Sorry.
There was a little bit of confusion about how much time there was to get registered, and I certainly didn't want to make the members of this committee wait. Should I proceed?
Not yet.
Okay.
What's your name, ma'am?
Stacy Sutton Kirby.
All right, if you would please state your name, who you're here on behalf of, and what your position is.
Yes, my name is Stacy Sutton Kirby.
You say- Okay, we're going to need you to register.
Sure thing. I'll be right back. Thank you. I tried.
Can you register here? Yeah, she's right here, but can she register here or does she have to go back out? Yeah, if you can do it at the kiosk, please. Thank you. Is there anything we can do in the interim? We can't do anything before that, right? So should we go to Geo next since he's in your, and then what Joe said? What's that? Do or don't? Do, okay. All right. We had a witness after all. Or we have. There she is. Now she's showing up.
Well,
All right, Ms. Kirby, thank you for being here today. We show you registered as Stacy Sutton Kirby on behalf of the Texas Humane Legislation Network and on behalf of yourself. Is that correct?
absolutely,
You'll be
yes.
testifying for the bill.
That is correct.
You may proceed.
Thank you. First, apologies to everyone on the dais. I had a misunderstanding about where we were at in the process. To begin, again, my name is Stacy Sutton Kirby. I'm Director of Government Relations for the Texas Humane Legislation Network, a 45-year-old Texas-based nonprofit that focuses exclusively on animal welfare laws and policy. The Texas Humane Legislation Network is also a member of the North Texas Link Coalition, an organization that studies the link between violence against animals, children, and domestic partners. Decades of research shows that violence inflicted on animals is the single greatest predictor the abuser will escalate to hurting people. Further, unless interrupted early on, animal abusers have a very high incidence of recidivism. House Bill 598 would deter repeated abuse by creating a criminal offense for possession of a non-livestock animal by someone previously convicted of the most heinous forms of violence against pets, companion animals, and service animals. For example, attacking or killing a service dog, the specially trained canines that our Texas veterans rely on to navigate everyday life. Or when someone tortures an animal by intentionally depriving them of food, water, care, or shelter, a common tactic of domestic abusers who seek total control over other members of the household by demonstrating the pain they can inflict. Or those convicted of organized animal fighting, the dog and rooster fighters, whose organized crime syndicates also engage in human trafficking, drug trafficking, and money laundering. People convicted of these crimes are not currently prohibited from acquiring more animals after serving their time or completing probation. This causes a legitimate concern that Texas law does not adequately prevent future violence. Prosecutors trying these cases often see the same offenders over and again, sometimes immediately after concluding the last criminal case against them. Consider the school shooter in Uvalde, who had a history of repeatedly torturing animals on social media and was photographed with their deceased bodies before he attacked the children and teachers at Robb Elementary. If only this young man could have been diverted from his path when he first engaged in animal cruelty. Sadly, House Bill 598 is needed now more than ever. During the pandemic, the Dallas Police Department, and I'm sure they're not alone, but their stats were easily handy. They saw a huge jump in reported incidents of animal abuse. In 2020, 28 cases of animal abuse were reported. In 2021, there were 125. Turning a blind eye to the red flag of animal cruelty is something our children, families, and communities can't afford. One more moment. 598 is the next logical step in closing the loopholes that allow abusers to continue to access animals. I'd be happy to take any questions.
Thank you, Ms. Kirby. Members, are there any questions for Ms. Kirby? Yes.
Hi, Ms. Kirby, and thank you so much for all you do for animal welfare. My question is about the shooter in Uvalde and that he was doing these cruel things to animals. Was he ever caught or was anything ever done to him?
To my knowledge, there was no prosecution of him for his crimes attacking and killing animals, but there was widespread knowledge he was committing these crimes. So apart from enforcement and making sure that we do interrupt these abusers, I think we have the challenge of educating people how dangerous animal abuse is, because the kids that saw him on social media or that went to high school with him, I do believe if they had a better understanding, if we all had a better understanding of the trajectory of these abusers, then he may have been interrupted, possibly diverted from what happened.
Members, any other questions? Thank you, Ms. Kirby.
Thank you.
Is there anyone else here who wishes to testify on, for, or against House Bill 598? If not, Chair recognizes Representative Shaheen to close on this bill.
Thank you, Mr. Chairman. I close.
There's no objection. House Bill 598 will be left pending. Any objection? Chair hears none. HB 598 is left pending. Thank you. Chair calls Representative Caplione and lays out House Bill 611 to explain the bill.
Thank you, Mr. Chairman and members. Thank you for the opportunity to address this committee today. Internet crime is a growing problem in our technology-focused world, specifically doxing. Doxing refers to gathering an individual's personally identifiable information, such as a home address or a telephone number, and posting it publicly without permission, typically with the intent of humiliation, stalking, identity theft, or harassment. Chairman, you and most of the members here today have all been victims of doxing. Last session, the home addresses of the entire membership of the Texas House of Representatives were published so that political protesters could find your house and protest on your doorstep. Doxers may target government employees to identify law enforcement or security personnel, demonstrate their own hacking capabilities, or attempt to embarrass the government or yourselves. Because doxing is a relatively new phenomenon, Texas currently does not have any specific law making doxing illegal. This House bill would fix that. House Bill 611 would make doxing a Class B misdemeanor up to a Class A misdemeanor if the offense results in bodily injury. I'm happy to answer any questions that you may have.
Any questions for Representative Caprileon? All right. Hearing none.
Reserve the right to close.
Thank you. All right, is there anyone here to testify on, for, or against House Bill 611? Seeing none, Chair recognizes Representative Caprileon to close on the bill.
Thank you. Once again, thank you for considering House Bill 611, and I close.
Representative Caprileon, would you like for this bill to go to local and consent?
What do you think? Yes. Yes, I would.
You can't amend it there.
Members, are there any questions for Leon?
Members, any questions for Representative Caprileon? Like pending, then we don't need to refer.
Third reading.
Okay, yeah. All right. Hearing none, HB 611 will be left pending. All right, Chair lays out HB.
Ron Goldman's? Yep. Chair lays out House Bill 393, recognizes Chairman Goldman to explain his bill.
Thank you, Chairman Moody. I thought I was going to get some home cooking there with Chairman.
No, that's
Cook.
why I had to step in.
Right,
I don't,
exactly.
You know, can't make it too easy.
Thank you, Chairman Moody, members of the committee. House Bill 393 creates mandatory restitution for a child whose parent or guardian was a victim of intoxication manslaughter until the child reaches 18 years of age or graduates from high school, whichever is latest. In 2021, the Texas Department of Transportation reported 1,077 fatalities in crashes involving driving under the influence. Preliminary numbers from 2022 are 1,323. This type of restitution-style bill for victims began in Missouri, and House Bill 393 is modeled after the Tennessee General Assembly law passed in 2022. To date, 8 states have introduced their versions of this law, with Tennessee being the first and only to pass the legislation. House Bill 393 does not take away from civil suits and would run concurrently with those remedies. With House Bill 393, we hope Texas becomes the second state to follow and provide justice to children whose parents were victims of intoxication manslaughter. With that, I'm happy to answer any questions and reserve my right to close.
Thank you, Mr. Chairman. Members, do you have any questions for Chairman Goldman this time? Nope. All right. We'll move to testimony. Chair calls Carol Levin. And Ms. Levin, you're going to hear me say this again. State your name, whom you represent, if someone other than yourself, and your position on the measure.
It's good afternoon now, I guess, right?
Yes.
Not good morning. Good morning. Good afternoon. My name is Carol Levin. I'm representing Mothers Against Drunk Driving for Bill 393 in support of that bill. This bill is also called Bentley's Law, which Matt is definitely in favor of. And thank you to Representative Goldman for his authoring this important legislation to require impaired drivers to pay child support when an impaired driver causes a crash that kills a parent or guardian of a child under 18 years of old. Matt also thanks the authors of similar legislation to HB 393, including HB 2110 by Representative Swanson and HB 1202, Representative Vasut. Texas still has a drunk driving problem. According to NHTSA, in 2020, 1,495 people are killed in your state. This is 100% preventable. On a personal level, I am a victim. I lost my son and my future daughter-in-law to a drunk driver in 2006. This brought me to Mothers Against Drunk Driving and brought me to legislation. MAD believes that passing this proposal is a victory for human rights. If this person makes a choice to drive impaired and kills a parent, the person will encounter another consequence for their deadly decision. To the victim of the impaired drivers, this proposal allows for another avenue of restitution to help ensure justice. Mr. Chairman, members of the committee, thank you so much for allowing me to testify on behalf of Mothers Against Drunk Driving. We urge you to support our bill 393.
Thank you, Ms. Levin.
Thank you.
For clarification, I know you mentioned some other bills that look similar or are similar. For purposes of your testimony today, you're testifying in favor of HB 393, correct?
Correct.
All right, thank you so much. Members, do you have any questions for Ms. Levin? No? All right.
Thank you very much.
Is there anyone else who wishes to testify on, for, or against House Bill 393? If not, the chair recognizes Chairman Goldman to close on his bill.
Thank you, Mr. Chairman. Members of the committee, I close.
Thank you. If there's no objection, House Bill 393 will be left pending. Is there objection? Oh, do you want it? I will entertain your question unless Mr. Goldman wants to come back up.
The question I had was, so this is in lieu of them being behind bars, right? So, or is it in addition to?
Part of the restitution. I think it's part of the rest. It's allowing it as as restitution. So restitution generally as a concept is trying to, create balance in the system. Easy example, graffiti. All right, well, you got to pay for the property cleanup.
Sure.
Right, that's restitution. We have that tool in our tool belt as we handle, individuals who are justice involved. In this case, you need to statutorily allow this as a form of restitution, which is what the bill does.
But the defense attorneys would not just say, okay, give them sort of probation and have them pay child support in lieu of being behind bars.
Well, prosecutors have a lot of tools at their disposal, right? So that's why we leave that up to their discretion. This is giving them another tool in this circumstance, if it is the right thing to do and possible. Sometimes restitution isn't attainable, given any particular situation. But this is a tool that, in these cases, Chairman Goldman is asking to send out to the prosecutors. I think it's something that has been done in Tennessee already. So we'll take a deeper look at it.
Thank you.
If there is no objection, the House Bill 393 will be left pending. Is there any objection? The chair hears none, and House Bill 393 is left pending at this time. Thank you for your patience, Mr. Smith. Chair lays out House Bill 469 and recognizes Representative Smith to explain the bill.
Yes, sir, Chairman. Thank you very much. And thank you, Vice Chair. Members, I appreciate your time and your attention to this bill. It's not quite as weighty as maybe some of the other things that you've heard this morning, but still very impactful to jurors all across the state and courts and court personnel. Under current law, a party is allowed to request that jurors be sequestered. While there are some cases in which this is necessary, most don't involve situations where this hardship on the jury or court is warranted. HB 469 seeks to address this issue by still allowing either party to make a motion requesting the jury not separate, but creating a deadline to do so. The deadline to make this request is no less than 10 days before jury selection begins. If the court has given its charge to the jury, either party may still request that the jury not be allowed to separate. At this point, the court shall hold a hearing to determine whether or not good cause exists to allow the sequestration. These changes are a vital update to the process and will help jurors and the courts prepare lodging, transportation, meals, and overnight deputies in the case that a sequestration is deemed necessary. Thank you for your consideration of HB 469, Mr. Chairman, and I do believe that we have some very valuable and very serious witnesses.
I don't know about serious. No, I'm kidding. Members, do you have questions for Representative Smith? Okay, we'll move on to testimony. Chair would call the most honorable and distinguished Judge Larry Phillips. who's since cleaned up.
Mr. Chairman, Vice Chairman, and committee members, thank you for the opportunity to come share. I'm Larry Phillips. I'm a district judge in Grayson County, Texas. And and I'm speaking on the bill just because as a judge, I don't know whether I can speak for it or not. But so we had I've been a judge now for about 5 years after I left the legislature. And this year we had a jury trial. And about Wednesday, about 2 o'clock in the afternoon, the jury had the case. It had been given to them for them to decide. And the defense lawyer comes in and hands me a motion and says, I want to sequester the jury. And I'm like, okay, surely there's got to be, what's the reason? Judge, it just says, I want to sequester the jury. Okay, well, I read the law. I'm going to follow the law because it's what it says. And if you see the current statute, which we're seeking to amend, that was passed in 1966, and that was before I was a lawyer. Mr. Chairman Darby wasn't a lawyer then either. Thank you. And so prior to that, I think it was around the country, the law started to change to make it clear that you could release jurors so they could go home at night. You didn't have to put them up and keep them together. And so I think that's why this law was passed in 66, because it's really phrased, they may adjourn the jurors. I mean, that's what it says, they may, that's the first of it. But there's this mandatory provision in here is after the jury has received the jury charge and it's their time to deliberate, either side can ask, or the judge, to keep them and not let them separate, not let them leave. It's very expensive. Anyway, so that afternoon, I was like, well, what do we do? Well, we need to get hotel rooms. We've got to get off-duty deputies because you have to have deputies do them. How are we going to tell them that they can't go home that night when we didn't tell them that before they started jury service? This allows us at least 10 days before to know we can make plans. And if something comes up during trial, and you know it can, especially the attorneys here, they know that, and I'm going to hand these out. They know that something can happen during trial, so we have to allow for, late filing, so to speak. That's just, I think, proper. This only applies in felony criminal cases, is the changes that are suggested here. I've got some examples from other states of how they do sequestration, and then I also have some statements from a couple of jurors, a couple of counties, and what they put in this, so that they kind of let you think that you're going to get to tell the judge this before you're ever picked, what they're going to have to tell you if you're going to stay overnight. So that's the basis of this. At the end of the day, the jury deliberated and finished that day, and they actually found not guilty. Normally, what we would do, if they haven't finished, we'd send them home. We'd tell them not to discuss the case. This happens all the time. The judges in my courthouse, none of them had experienced this before. So we just want help. Be glad to answer any questions.
Yes, members. Representative Bojani.
Can you imagine any circumstances where, you find out last minute? And again, I don't practice. I just want to say I don't practice litigation, so give me some grace here. But is there any circumstances where you don't have 10 days to give notice?
Right, and that's why we made an exception here. So a very good example with this. Let's say that sometimes the media doesn't find out about a case till if it's trialed. Just that rumor starts going around, and then all of a sudden it gets this huge attention. Doesn't happen very often, but that's an example. Or if there is a witnesses that, or somebody that's been threatened, and you're concerned about that jury, and you don't want them to, you want to keep them together because there's threats. So that's why we put in there an option for good cause that they didn't bring it before, and good cause would be they didn't know about it. It just arose. It's a great question. Yeah, very good.
All right, members, do you have any other questions? Judge Phillips? Yes. Now you're in trouble, Judge.
No trouble.
You poked the bear now.
I know.
No, what does this bill have to do with public education?
Chairman Darby, it helps children that go to public schools, parents come home at night and feed them without having to stay in a hotel at the expense of all of the county citizens.
Well done.
Well, during my time in the legislature, there have been very few members that have had such a passion for public education. I had to endure lots of hours on the floor listening to you rail.
Rail, yes, I agree.
And so
I
just,
apologize. Don't let that, don't hold that against my much better, better looking successor. Yeah, don't hold that against him for this bill.
I had to at least, let me congratulate you on your service in the legislature. Your time here was well spent, and I know the folks in your district enjoying your service as district judge.
Thank you
for coming.
Thank you, Chairman. I agree. Same for you. Same for you.
I will echo that reluctantly.
Yeah, reluctantly. And for some of y'all know, I would always have no problem being the first one to ask the freshmen questions when they present their first bill, which y'all will get to experience. So
Thank you.
That was fun.
Appreciate your testimony. Is there anyone else wishing to testify on for or against HB 469? Chair sees none and recognize Representative Smith to close on his bill.
Thank you, Chairman, Vice Chair. Yes, and I just want to echo the kind comments that were made of my predecessor. For the freshmen that may not know, my predecessor was in the legislature for 16 years before I showed up. And so this is what you're stuck with for a little bit at least. But no, I really appreciate him coming and his wife, Robin, for taking the time to come down here. And they've been a great asset to me and to the state of Texas and in connection with this bill. I would just close.
Thank you. Members, before we let Representative Smith go, any questions? No? Thank you, sir. If there's no objection, HB 469 will be left pending. Is there objection? Chair hears none. HB 469 is left pending at this time. Chair lays out HB 178 and recognizes Representative Murr to explain his bill. I do want to note for planning purposes, the Texas House convenes at 2 p.m. It is now 12:43 p.m. And aside from Mr. Murr's bill, we have two more bills to hear. So just would like to be efficient with our time. Mr. Murr, I know you always are.
Thank you, Mr. Chairman. I'll be very efficient. Members, this bill is third time's the charm, so I filed this in 2019, 2021, and again in 2023. This bill deals with a word that has become very common for us, which is fentanyl. I filed this bill really to be an opportunity for an enhancement tool for prosecutors and those that deal with crimes that relate to fentanyl. So this bill adds a provision in Chapter 38 of the Code of Criminal Procedure that would require authorized labs to test controlled substances for possible fentanyl if it is, quote, reasonably possible that the substance is or contains fentanyl. Now, I worked with our state agencies, including DPS, to add language into this, and that's where the suggestion of reasonably possible comes from, and it could mean any of the following four definitions. One, if a submitter indicates on the lab submission form, an LAB 201, or other submission paperwork, such as an offense report, that the substance is believed to be or purported to be fentanyl. Two, if the evidence is identical or similar to the manufacturer markings and packagings of fentanyl products. Three, if a forensic scientist suspects a submitted item may be fentanyl based on their training and experience. Or four, all unknown powder, crystal, and liquid substances. And let me just kind of go off on a quick tangent. So several years ago, and part of the many hats that I wear, I take criminal cases in a small town, and I learned that DPS troopers were no longer conducting field tests for powdered substances. And that was a departmental determination that they made to protect their troopers from something that was previously unknown to all of us. It was called fentanyl. Now, we still have deputy sheriffs and we have police officers in municipalities that still do their field training tests. So they go over on the hood of a car and they check it if they have a stop. But our DPS troopers literally took the step in order to protect troopers out there on the road or in an investigation from doing a field test, and said everything goes to a state lab. And so I think there will be a resource witness that will tell you how busy the labs are and how we don't want to unnecessarily burden the labs with additional testing, and there is a lot of testing going on. That being said, the purpose of fentanyl is essentially to cut down the amount of drugs that a drug dealer is selling. So if you think about it, Fentanyl increases the potency of other controlled substances, such as cocaine. So I can put less cocaine in my product, I can put a little fentanyl in there to boost it, and then I can charge you the same or more money. And that's what's really going on. So it's all about money for cartels and those that are making money off of addicting people to controlled substances. That being said, it puts in danger young people, law enforcement, and first responders. So consequently, if we have a robust mechanism in place in which we can test and then correspondingly punish people who incorporate fentanyl into their products, then I think maybe we can change the way the business is attempting to be performed in the state of Texas. And so happy to answer any questions, reserve my right to close, and I do think that there will be a DPS witness to provide additional information about labs. And I do think there is a fiscal note. So.
That's okay. Members, do you have any questions for Chairman Murr at this time?
Thank you.
And since you've teed it up, we'll go ahead and call Chief Brady Mills. Mm-hmm. Yeah, because you've got to have the...
Good afternoon, Mr. Chairman, members. My name is Brady Mills. I'm the chief of the Crime Laboratory Division for Texas Department of Public Safety. I am on the bill as a resource witness and be happy to answer any questions.
Members, do you have any questions for the chief? Dig into some of the issues that Chairman Murr raised. Yep. Representative.
So as far as the fiscal note that Chairman Murr mentioned, is that for a statewide lab, I'm assuming?
That is for the DPS system. So that's for all of the 16 labs that we have around the state.
Okay. And so can you tell us a little bit more about that? Would all jurisdictions throughout Texas be able to access it and things like that?
Yes, sir. Yeah, we cover about 75% of the state and about half the population of the state as the state laboratory system. We do have local partners that are doing seized drug testing as well. And that fiscal note is for us. There potentially would be impact to the local partners that we have as well for the additional testing. The fiscal note is based on additional personnel to test some of the cases that we're not testing today. We test about 55,000 drug cases a year. We test to the best case or the highest penalty. So we don't, if a case is submitted to us, we don't test everything in the case. We just test to the highest penalty or the best case for prosecution to support the courts or to support the investigators. And then currently we're not testing misdemeanors. And so when we looked at this particular bill and with the new statute, it would be to test everything submitted to the lab. We looked at what we weren't testing and then determined how many more personnel we would need to be able to complete that testing.
So all of the money, the approximately 17.8 million is personnel?
There is about $1 million that is rental facility for space. In the first year, there is some capital equipment purchases for some additional GCMS instruments, but the vast majority of it is for personnel costs. I think there's about 50 personnel that's being requested.
Okay. And since the bill does require, testing to be performed, what are the other jurisdictions? Do they have their own labs? I mean,
yes, sir. Yeah, so our local partners are covering more of the larger municipalities, and they do additional seized drug testing in those locations as well.
Thank you.
Thank you. Chairman Darby, yes, sir.
Hardly reach, I'm sorry. Chief, I was just looking at the fiscal note, and I noticed that part of the numbers shown in the methodology was the crime lab reported that no analysis was done on 31,554 drug evidence cases in fiscal year 22. So I guess this bill will require you to do drug tests on all of that.
Yes, sir. That is the methodology we used. So those cases were there misdemeanor cases that we didn't test, or there are cases that were not going to court or through some sort of court adjudication process. So we closed those out with no analysis. We see this bill as requiring us to test the 55,000 that we are testing, but then also if we use 22 numbers as an example, it would be an additional 31,000 cases.
So these are your figures to require an additional FTEs of 56?
Yes, sir, that is correct.
Okay. Require 15 gas mass spectrometers at 120,000 each?
Yes, sir.
All 56 would require a desktop computer?
Yeah, there's a standard buildup for each one of our FTEs, and so they would require a computer space, desk space, and consumable costs and some other things to outfit that individual to be trained and be able to do this testing. So that is wrapped into the fiscal note.
Thank you, Mr. Chairman.
Thank you. Yes, Representative Bojani.
So we're saying that we're retesting when we think that there may be reasonable grounds to have fentanyl in the substance, right?
So it's not retesting, but it is testing for cases that are submitted when there's a reasonable assumption that it may contain fentanyl. How we use that is we said that any powders, crystals, or liquids, and so we excluded plant material and we excluded gummies, which we're seeing are more infused with THC products. But then everything else we lumped in to go through the testing for the presence of fentanyl.
Okay. Would it be more cost effective if we tested, like, let's say if we did not test for fentanyl, but we figure out that it may contain it? Would it be more cost effective to do it the first time around? Because I think we're testing it for the highest penalty, but then second time we may have to go back to do it.
So when we test for the highest penalty, we would be able to identify fentanyl through that testing process. So for the 55,000 cases that we are testing and running through a GC gas chromatograph, we would identify if fentanyl is present. Okay. So the additional testing that's needed and the resourcing to be able to do the additional testing are the cases that we are not testing at all today.
Got it.
So it's not a retest, it's the additional testing.
Okay, thank you.
Great questions. Thank you. Any other members? No? Thank you, Chief.
Great, thank you.
Chair calls Paula Blackman. All right, go ahead and state your name, whom you represent, and your position on the bill.
Hello, thank you. Good afternoon. I'm Paula Blackman, and I'm representing the City of Dallas, and I represent East Dallas, which is District 9, here in support of the bill. So fentanyl has made its way into our communities, specifically into my community, into Dallas. And it's into North Texas, and we believe this bill before you today essentially is Dallas's current practice in testing for fentanyl. We believe that implementing it statewide will allow Texas to further access the scope of this crisis. Our police department already submits all drug evidence related to criminal cases for laboratory analysis, where the sample is analyzed to tell us what and if any kind of controlled substance is present, and this includes fentanyl. It seems that the fentanyl crisis has hit communities, and it is continuing to hit our communities. I am not only an elected official, but I'm a mother of 3 boys who are either finishing college or have finished. Most of you are parents too, and most of you have served on your city councils. When I was in city council about a year ago, we get analysis of things happening in our district. And I got one of a friend of my son's who showed up dead from a fentanyl overdose. When you're in a committee meeting or in a council meeting and you get an email that you know the address and you know what is happening, it's very personal. And that's why I'm here before you today saying, please help us help your communities be safe. As it's been stated, people think they're buying a Xanax or an Adderall. And my son was saying, Mom, I need to study. And I'm like, do not go on a Snapchat and buy something. Please do not. So we are asking you here today to help us protect our communities. This is a huge issue, and we can work together, and we appreciate and applaud everybody coming to our efforts. In Dallas, we are bringing together our nonprofits, our partners in the county, our partners in schools, because communication and information is important. And with this law, we can move our families together in our communities. So I appreciate that you taking this topic up, and I applaud your support and the leadership of Governor Abbott in making this opioid response an emergency item in this session. I thank you for your time, and I'm happy to answer any questions you may have.
Thank you, council member. Do you have any questions? No? Thank you. Thank you for your patience today, and thank you for traveling. Is there anyone else wishing to testify on, for, or against House Bill 178 at this time? If not, Chair recognizes Chairman Murr to close on the measure.
Mr. Chairman, members of the committee, I appreciate you taking time to listen and hear testimony about the bill.
Yes.
Chairman Darby?
You know, clearly, the fiscal note's going to be an impediment. Do you agree with the numbers set out in the fiscal note that it would require an additional 31,000 tests to be performed?
In 2019, when I first drafted a version of this bill, it was requiring testing of essentially every submission. And so I do think that working with DPS and their suggestion that not every submission is applicable has dialed that back a bit. But you have a state of 30 million people with 16 different labs. And so when they say that it could be 56 different new employees, I can't disagree with that. What you heard was over 30,000 new tests were going to be conducted each year. So if you divide that by per month basis, it's a lot. But if I go back and I look at the percentage of criminal cases that the district attorneys and county attorneys that I represent have, predominantly they're controlled substance cases. They are narcotics or dangerous drugs at a misdemeanor level. So that's a majority of what's in our criminal system right now. And so every one of those won't proceed unless we have a test before an indictment is typically the best practice. So I think that this allows an enhancement to be available, but we do have to have that knowledge. And if we have decided that fentanyl is important enough that the state of Texas ought to be testing a lot for it and keeping track of those numbers, I think that would also help us in our policymaking going forward. So at the end of the day, I don't dispute that it has a fiscal note and that more employees would be required.
Exactly. And part of the impetus for your bill is to help protect first responders and, of course, DPS, other law enforcement, that their lives and safety were in jeopardy in not having to personally handle that substance. Now they can send it off and know this tested properly.
And they know that it gets tested. That's right.
Okay. Thank you. Thank you for the bill.
Mr. Chairman?
Yes. Do you have a question? No? All right.
Then I appreciate your time. If you have any other questions outside of this, please let me know.
Thank you, Chairman Murr. I appreciate your patience with us. If there's no objection, House Bill 178 will be left pending. Is there objection? The chair hears none. House Bill 178 is left pending at this time. Thank you, sir. All right, I'm going to hand off to Vice Chair Cook. Before I do that, point of personal privilege, right sitting in the back of the room, it's shaking Andy Murr's hand, is Pete Gallego. The gentleman I mentioned to you last week when we started this hearing, that was my chairman, my freshman session, who made a horrific error of handing me responsibility, and I've kind of run with it from there. But if you have time, you should go meet him and talk to him. He is a wealth of legislative wisdom. So I'll hand off.
All right, Chair lays out HB 188 and recognizes Chairman Moody to explain the bill.
Thank you, Mr. Chairman. I'll try to be brief. I know we're in our last hour, and I'll remind the witnesses that are here on these bills also so we can be efficient with our time. If this bill seems a little bit confusing, it's only because the law that it's amending is actually confusing and misleading. In a death penalty case, juries don't get a general, does this person deserve the death penalty question. Instead, they make their decision by answering a series of special issues. Is the person a future danger? Did they intend or anticipate that a life would be taken if they were convicted as a party? And are there any mitigating factors urging life instead of death? Right now, the instructions jurors get suggest that only 10 of them need to agree on each of those issues to sentence someone to death. That simply is not true. The law is and always has been that jurors have to be unanimous, and in other parts of their instructions, jurors are told they have to be unanimous. I don't know why we have these bizarre instructions suggesting otherwise in this part of the instructions, but they've led jurors in real cases to vote against their conscience, thinking that their vote didn't matter. House Bill 188 eliminates the confusion by accurately stating the law. To make a finding for the death penalty on a special issue, the jurors have to be unanimous. And if they aren't, they've answered that issue for life in prison without the possibility of parole. It's a simple idea and a very simple bill. People should know what the effect of their vote is. Confusion shouldn't be a part of any trial, particularly one that involves life and death. Members, I'm happy to answer any questions. With that, if there are none, I'd reserve my right to close.
Great. Members, any questions? Chair calls Jennifer Allman. Ms. Allman, thanks for being here. If you would please state your name, who you're here on behalf of, and if you're testifying on, for, or against the bill.
My name is Jennifer Allman, and I'm the Executive Director of the Texas Catholic Conference of Bishops, and I am testifying in support of House Bill 188. Obviously, I want to be clear that the Texas bishops oppose the use of the death penalty in every time and in every case. But this bill really isn't fundamentally about the use of a death penalty. It's really a jury rights bill. Jurors are lied to, and that death penalty conviction is based upon a lie. And you cannot have justice if it is based upon a lie. Fundamentally, that's what this is about. I want to give you a very current real-world example. There was a case last week in Lubbock in which the defendant, Hollis Daniels, pled guilty to murder of a police officer, Floyd East Jr., on Texas Tech's campus. He shot and killed the police officer. He admitted to his guilt, and they went straight to sentencing. That sentencing took 3 days. The jurors sent in 17 notes to the judge asking for clarification of this issue, of multiple issues, but this being among them. And each time the judge was required by law to simply send back the same confusing instructions. So as a juror, these people are sitting in this room, giving of their time away from their families, away from their work, spending 3 days trying to determine if they will make a vote to end the life of another human being. And they're confused, and I can't imagine the level of conscience that it involves for them, the level of pain and confusion that it involves for them. It is imperative, regardless of anyone's position on the actual death penalty, that I think we should all be able to have the common ground agreement that we tell the truth to jurors about their role in the process so that they can make informed decisions. So we thank Representative Moody for bringing this bill again, and we hope that we can get it through the Senate. We know that the House has been supportive of it and passed it last session. So thank you for your time on this issue, and thank you for your comprehensive look at death penalty reform, including all aspects such as jury instructions.
Thank you, Ms. Allman. Members, any questions? Thank you for your testimony. Next chair calls Benjamin Wolf. Mr. Wolf, you would please state your name, who you're here on behalf of, and if you're testifying on, for, or against the bill.
Good afternoon. My name is Benjamin Wolf. I'm the director of the Office of Capital and Forensic Writs. I'm testifying on this bill. I can confirm that the jury instruction is confusing. It's confusing to lawyers and it's confusing to jurors. The foundation of a criminal justice system is a jury, and it's how reliability is ensured. The U.S. Constitution guarantees a right to trial by jury, and in capital cases, that jury verdict must be unanimous. And I can tell you that there is no legal reason why the jurors should be instructed that to answer yes to mitigation, 10 jurors must agree. You need one. There's no legal reason why 10 people would need to agree that a person is not a future danger, because you need one. The law is actually clear. Unanimous verdicts are required, and to find sufficient mitigation, one juror. You need one juror, and just to follow up on Chair Moody's testimony, this does have real and that of Jennifer Allman. This does have real-world consequences. We had a case some time ago where a capital juror gave us an affidavit that said, I'm going to read a few sentences from it. This is during the punishment phase deliberations, it became clear that I was the only juror voting for life without parole. The other juror initially voted for life instead of death, but eventually changed her mind. I tried to explain to the other jurors why I felt that death was not an appropriate punishment, but after several hours and one night of being sequestered, it's pretty clear I was not going to change anyone's mind. In addition, I learned that my daughter was very sick, and so I felt a lot of pressure so I could go home. Later. Ultimately, I went back to deliberations. She brought her concerns to the judge and was instructed to keep going, as in the case that Ms. Allman referenced. Ultimately, I went back to deliberations like the judge instructed me to, and I thought about whether I could find a way to agree with the rest of the jurors. Because of all the pressures from the other jurors and my daughter being sick, I decided to change my vote to death. At no time did I truly believe that the evidence presented warranted a sentence of death, but I had to stop fighting what seemed inevitable. I would submit that was because she did not understand the jury instructions. Happy to answer any questions.
Any questions for Mr. Wolf, members? All right, just to clarify, this is your testimony that you're giving, correct?
Yes, testifying on the bill.
Yep. Great. Thank you.
Thank you.
Is there anyone else here who would like to testify on, for, or against House Bill 188? All right, members, if not, we'll ask Chairman Moody to close on the bill.
Thank you, members. I'm happy to answer any questions. This is one of those that I wanted you to think really deeply about today. But apparently, it's a non-council draft, which is something you all find out is can be problematic, even though it shouldn't be. So look forward to your favorable consideration of this bill on a later date. But this is just honesty in the jury instruction. When we're talking about life and death, we shouldn't try to hide the ball from folks. It has been told to you today and in prior sessions. There is a juror that came here and testified himself about changing his mind because he did not understand that that it had to be unanimous. He figured since he was the only one, that it didn't matter. And why we would do that, well, I have my thoughts on why we do that, but we shouldn't do it. It should be accurate what we give to these jurors specifically in cases of life and death. Happy to answer your questions. If not, I close.
Members, any questions for Chairman Moody? Thank you, Chairman. If there's no objection, House Bill 188 will be left pending. Is there any objection? Hearing none, House Bill 188 is left pending. Chair recognizes Chairman Moody and lays out House Bill 218 to explain the bill.
We've been on a journey with this one. Members, this bill is a little bit long and complicated. Oh, do we have a substitute on this? Yeah, sorry.
The chair offers committee substitute to HB 218.
Thank you, Mr. Chairman. The essence of this bill is very simple, even though the language may be a little bit confusing. Right now, we're arresting and prosecuting people for low-level personal use amounts of marijuana. House Bill 218 changes that system to right-size the penalty. This is something that we've passed out of the House twice before, and the system that it creates is one that we have worked directly with the governor's office on the mechanics of how it would work in the real world. We've talked to JPs and constables. We've talked to the attorneys that will be prosecuting. We've talked to frontline law enforcement. We've tried to bring everybody to the table to make sure that the system works and the penalty that we're meting out fits as well, and we're not wasting valuable resources. I want to be very clear, though, this bill is not marijuana legalization. That's another bill going to a different committee. But this would maintain, thank you. This would maintain the illegality of possession of low-level amounts, but would right-size the penalty. Now, we've been talking about the reasons for changing this for years now, so I don't really want to belabor them here. But there are tens of thousands of arrests for personal use possession in Texas annually, and those cost our state hundreds of millions of dollars every single year. Not to mention countless hours of law enforcement and prosecutor time. And they also tag people, mostly young people, with criminal records that create lifelong obstacles to jobs, education, housing, and other opportunities. That's an awful investment and an awful outcome any way you slice it. Functionally, what this bill does is to change all that, functionally what we're going to do here is to make possession of a small amount of marijuana a non-arrest Class C offense. It requires courts to give the person who's ticketed deferred adjudication probation, and if the person successfully completes that, expunge the record of the offense upon their request. To be clear, this will not be supervised probation. Basically, the person is given a ticket, goes to court, they're assessed a fine, then the court tells them, you've got 6 months to pay and you need to stay out of trouble during that time. If the person does their part, the court dismisses the charges, and on a request of the individual, deletes the entire record of it. The person walks away lighter in the wallet, but without any criminal record whatsoever. The only difference between this and previous versions of this bill is that it incorporates another effort that we've been working on side by side with this to create parity between leaf cannabis and concentrates. In other words, when someone has a joint or a vape pen, we're going to treat them the same, which isn't the case under the current law, and you'll hear that from your different jurisdictions. The last thing I'd like to add is that the committee substitute is not a substantive change. We just filed a non-council draft initially, and so what you see in front of you is the legislative council version. So there is no substantive difference between the two. I'm happy to answer any questions about the bill. If not, I'll reserve my right to close. I know we do have a handful of witnesses here to testify.
Great, thank you. Members, are there any questions for Chairman Moody?
Just very briefly, Chairman.
Yes, sir. Mr. Harrison.
Sorry. Chairman Moody, could you just explain at a very high level the interactions with this bill with the transportation code? Because, I mean, obviously with any changes to marijuana law, nobody wants anybody driving high. As I read it, it only looked like it made a small tweak perhaps to the requirement to automatically suspend a driver's license. Are there any other transportation code implications here other than that one, which I caught? Or I think I caught.
No. The suspension of the driver's license is one of those collateral consequences that we were trying to remedy that really kind of catch people in a cycle of criminality. And so that's in here. We've, in the past, people get concerned that, boy, we're going to make it harder to arrest folks if they're under the influence. None of those things are changed under this. If that conduct is what you're engaged in, that is still illegal under the law. This doesn't change that whatsoever. This is simple possession.
So no changes other than that driver's license issue?
Yeah, it's a
Thank you
driver's
very much, Chairman.
Any other questions for Chairman Moody? All right, if there are no further questions, we will proceed to testimony.
Thank you, sir.
We have witnesses. Chair calls Jason Vaughn. Go to the next one. Chair calls Elizabeth Miller.
Good afternoon, and thank you. I'm here representing myself in support of this bill.
If you would, please state your name.
Elizabeth Miller. Sorry about that. I want to thank everybody for your time and for this fantastic legislation. I want to thank the chairman and his staff, past and present, for your excellent stewardship on this issue. I care a lot about it. It happens to be Rare Disease Day, February 28th. And although each individual diseases may be rare, there's 7,000 of them, so having one is not. 1 in 10 people, some estimates say, I haven't checked the math on that, have a rare disease. And I have something called hypermobile Ehlers-Danlos. And because of that, I have been using medical cannabis for medical reasons for a long time. For chronic pain, for some sleep seizure stuff, for some, it helps me with GI and appetite, and it even helps with some autonomic dysfunction. Don't worry, I'll stop, but you get the idea, a lot of reasons. Also, downwind of my EDS, I have some other genetic oddities and issues. One of those is a mast cell issue where if I use flour, I could have a very negative anaphylactic sized response. Not all the time, but it makes flour an unsuitable medicine for me. So I am forced to use a form that falls as a concentrate under current law. So in order to function and sleep and be here in front of you, I have to commit a felony every day, pretty regularly. And I've been saying that under oath now for a while and in front of people and on TV if necessary, because I feel strongly about that. I feel like Texas patients shouldn't have to live in fear. Just the current TCUP program is so narrow, I can't get the sufficient THC in the right form that my body can allow to keep the seizures and the pain enough to be here. So since my illegal use has allowed me to be here in front of you, I feel compelled. I don't have kids. I don't have a bunch of employees that depend on me. So I'm here to tell you there are a lot of patients that live in fear this way, right? And it affects us. And the other thing is I must speak out and note that although I've been doing this for a couple years now on TV and under oath, nobody has come for me, right? So as long as the enforcement is disparate, where a few miles from me, a young brown man didn't even survive a law enforcement interaction over small amounts. His name was Marvin Scott. But I'm still here unbothered, and I'll probably be unbothered. I mean, I don't want anybody to arrest me, but if they do, it could injure me. So I just wanted y'all to know that this still affects patients. Thank you for your time. I'm happy to answer questions now or later.
Members, any questions for Ms. Miller? Thank you, Ms. Miller.
Thank you.
Mr. Vaughn, the chair calls Amber York.
Good afternoon. How are y'all?
Doing good. If you would, please state your name, who you're here on behalf of, and your position on the bill if you're for.
My name is
against,
Amber
or
York.
On the bill.
I'm here to testify in neutral support of House Bill 218.
Neutral or support?
Neutral. I am a child of God, a widow, and a mother of 4. I am here to represent myself, my family, and Healthy Herb Farm. I say neutral because I do support penalty reduction. In fact, I do support full decriminalization of cannabis, or AKA marijuana. I do not support still imposing a fine. These fines are expected to be paid with U.S. currency. That very U.S. currency that states, "In God we trust." In fact, "In God we trust" is the official motto of the United States of America. Motto meaning beliefs or ideals guiding. But how can that be so? Do we really trust in God? He tells us in the Bible that he gave us herbs of the earth for the people, all through Genesis. In Proverbs, he even tells us in Ecclesiastes 38:4 that the Lord hath created medicines out of the earth, and he that is wise will not arbor them. He also tells us that we are made, created in his image and his likeness, correct? So we're all the same in his eyes. Titles do not matter. We're all the same. We're all his children. But as most of us know, time on this earth is short, it flies by, and we're all called to be kind, caring, and love our neighbors, helping each other through this life. Locking people in cages, causing chaos and ruckus in their life, destroying their families over this God-given plant is not loving each other. It's not caring for each other. In fact, it's quite the opposite. Making people choose between paying a fine for their freedom or buying groceries or basic necessities for themselves is not right, and it's very far from Christ-like. So we have the power to change this, to help these people, but will we? Or will we stand in front of our Maker on Judgment Day and tell him he was wrong? We knew better than he did, and we were locking his people up in cages over a plant that him himself put on this earth to help us. Now, I lost my husband of 18 years at 37 years old. I watched him take his last breath as I held his hand, and his heart stopped beating for the last time. The father of my 4 children and the man I had planned on spending the rest of my life with. He was diagnosed with the final stage of multiple myeloma, bone cancer. He was the strongest man I knew, took very good care of his family. But When he was diagnosed a few days before Thanksgiving, they give him a couple weeks to live. Told him to go home, tell your wife and kids goodbye, do what you need to do for the end of your life. We weren't going to accept that. So we put him on cannabis medicine. We, in fact, had him on the Not So Compassionate Use Act in Texas, and the recommendation was go to another state because what Texas offers is not enough. But he lost his job. He could no longer work. He's fighting for his life, and now we can't just pick up and move to another state. So we can't afford the medicine because of the cost on the Compassionate Use Act, so the only other way is to go to black market. Well, then on the black market, you're risking your freedom. You're risking getting your kids taken away, and you're risking your family being torn apart. If he would have been arrested and thrown in jail, he would have been dead long before the time he was.
Thank you, Ms. York.
Yes.
Just to clarify, you were testifying just on behalf of yourself, correct?
Myself and Healthy Herb Farm, which is a hemp farm in East Texas.
Great. Thank you very much. Thank you for your testimony.
Thank you. God bless y'all.
God bless you as well. Thank you. All right, Chair calls Jason Vaughn.
Hello, my name is Jason Vaughn, and today I'm just representing myself on behalf of HB 218. I wanted to go over, first off,
Can you clarify, are you speaking in support, against, or?
In support.
Okay, thank you.
Wanted to go over, obviously, in support, wanted to talk about a couple potential changes to the bill, if possible. One on, currently, I think it says that it would be up to a 1 ounce for a Class C misdemeanor. The governor has specifically called on 2 ounces for Class C. If that's what the governor's willing to go to, I see no reason for the body not to make that amendment. Another one is on the arrests of it. That's going to be one of the hardest things on this issue consistently. I've worked with a lot of our wonderful police officers around the state, and that is the thing that consistently they have told me is a holdup for them. I would prefer, I like that aspect of the bill, but I just wanted to mention that if it's, for me, and I know a lot of people I work with, if that is the hindrance on passing the bill, I would rather that kind of issue be held in Sandra Bland bill and others instead of stopping a bill like this, because it is time we finally get this done. And I greatly appreciate Chairman Moody's work on this over the years, but I will not keep the committee's time beyond that.
Any questions for Mr. Vaughn? Thank you for being here, and thank you for your testimony. All right, next, the chair calls Karen Reeves. That's the last one. Thank you for being here, Ms. Reeves.
Thank you for having me. My name is
Can
Karen
you give me
Reeves.
just a moment? Yeah, if you would please state your name, who you're here on behalf of, and if you're speaking for, against, or on the bill.
My name is Karen Reeves. I'm here to testify in support of House Bill 218. I'm here representing myself in Syntax Community Outreach. I support reducing penalties for cannabis possession, and this bill definitely is headed in the right direction. I have testified several times in the past sessions. I began advocating for my son. He's was a Marine reservist. He was arrested for being in the wrong place at the wrong time. My son took a felony charge at that time that he did not deserve. Then I came back and I testified on my own behalf, recalling a painful, humiliating story about my own arrest. It happened at the most vulnerable time in my life. At last session, I came back again in front of the Senate to testify on one of Moody's bill that made it that far about what happened to me when I was 18 years old. I witnessed a friend being arrested on felony charges. Now, the conclusion of my son's arrest, his charges were ultimately reduced, and he did do 2 years of probation and paid thousands of dollars in fines and lawyers' fees. Now, at the conclusion of my arrest, I ended up selling my car. I moved within a mile of the school. That happened in 2004. I still do not have a driver's license or own a car. Now, after I witnessed my friend being arrested when I was only 18, that was the most impact in my entire life. I was with my friend when he was pulled over. My attitudes about law enforcement changed. I began heavily drinking. I dropped out of college. I still think of those times. I want to come to tears because it changed my life. It estranged me from my family. And these things may not seem very traumatic to you guys sitting here, but when you go through an arrest and you're humiliated in front of God and everybody, and you've been searched, you've been charged, you've been taken to jail, that's something that stays with you for the rest of your life. So I'm here again, and I've testified before. What will happen to me if I'm arrested? What will happen to me if my house is raided? I'm still going to be arrested. I'm still going to be charged, and I'm probably going to be taken to jail. I live in fear every day. I've lived in fear since I was 18. People across the state, thousands of people are going through what I've been through. I'm here. I'm compelled, like others are here today, to continue the fight to reduce these penalties. I would not wish what I've been through in my life on anyone. I'm now a proud teacup patient, but I don't have money to get access to the medicine statewide. But if I were arrested or pulled over in a friend's car, I would have to, I don't know what I would do. Like I said, my health would suffer. I would be devastated financially. And I've just now got a relationship back with my mom for a long time. You guys are here. I see the compassion in your eyes. We're here today to support Moody, and we want to push this bill forward to the Senate ASAP. We don't want to live in fear anymore.
Mr. Reeves, thank you for your testimony. If you can, just wait there for just a moment. I just want to clarify that your testimony today was simply regarding House Bill 218.
Yes.
No others, correct?
Nope.
Members,
But I'll be back.
I bet you will. Any
better
members,
watch
any
out.
questions for Ms. Reeves? Thank you for being here.
Thank
Thank you
you
for your
again.
testimony. Is there anyone else who wishes to testify on, excuse me. We got one more. David Bass. The chair calls David Bass. Mr. Bass, if you would please state your name, who you're here on behalf of, and if you're testifying on, for, or against the bill.
Thank you, Chair. My name is David Bass. I'm representing myself, and I support the bill.
Thank you. You may proceed.
I served 25 years in the U.S. Army.
Thank you.
Texas has 1.4 million veterans. I estimate from my work with Texas Veterans for Medical Marijuana, and we've been advocating here at the Capitol since 2013. I've spoken to thousands of veterans all over the state of Texas. I go to our veteran service organizations and educate them about medical cannabis. I estimate that 200,000 veterans use cannabis in Texas, primarily for PTSD and chronic pain from injuries and wounds. This is based on current surveys that show between 13 and 18% of Americans admit to using cannabis regularly. So if you extrapolate that to our veterans, that's about 200,000. Texas veterans obtain cannabis from three primary sources. Of course, the first is the illicit market. The second is hemp derivatives, Delta-8 and Delta-9. And the third is the compassionate use program. I'm a patient, thanks to all of you, since last year, legally using cannabis for PTSD and chronic pain in the compassionate use program. My estimates, based on talking to thousands of Texas veterans, is that we currently have approximately 10,000 veterans enrolled and actively using compassionate use program medicine. My estimate is 40 to 50,000 veterans are using Delta-8 and Delta-9 as medicine, which leaves us about 150,000 other veterans in the illicit market. Now, I'm going around Texas educating veterans about the compassionate use program. I want them to be legal, but there's obstacles, and you've heard a couple of patients mention those, and Representative Stephanie Click's working hard to resolve these issues. But we're not there yet, and so we have this really large number of veterans still in the illicit market using cannabis for PTSD and pain primarily, and they're at great risk. And so this bill would really help those veterans avoid really adverse consequences in their life. And that's why I support this bill.
Thank you for testifying today, and thank you for your service to our country. Members, any questions for the witness? Thank you, sir.
Thank you, Chair.
Do we have anyone else here that wishes to testify on, for, or against House Bill 218? Seeing none, Chair recognizes Chairman Moody to close on the bill.
Members, thank you. I appreciate your attention to this. This is an issue that we're going to continue to work on. I think I think it was perfect to have Mr. Bass kind of synthesize why it's important to talk about the criminal law lane of travel when it comes to cannabis policy. There's retail market, there's medical cannabis that you talked about, and then there's the criminal justice lane of this conversation. The reason is because we don't in Texas have a retail market. We have a limited medical market that is broadening out slowly. There are still people that might be in that program that are seeking cannabis through other means, and they're going to be subject to the criminal penalties that exist under our law. And you heard about people that are willing to take that risk because they want to treat themselves. You heard a lot about medical cannabis, even though this is not a medical cannabis bill, but that's the way they intersect, right? People are going to try to treat themselves in one way or another. So how are we, what piece of that puzzle can we put together for them? I think generally that's an important reason why we should pass this. The other is largely young offenders are caught up and saddled with convictions that hinder their growth as Texans in general, right? When it comes to education, job opportunity, housing opportunity, and other things. So we're trying to serve both purposes. As the other parts of this conversation advance, which they're going to, this is a good step to create a floor in this state to treat people more fairly. And with that, I'm happy to answer any other questions.
Members, any questions for Chairman Moody regarding House Bill 218? Thank you, Chairman Moody.
Thank you. Close.
Committee substitute to HB 218 is withdrawn, and if there's no objection, House Bill 218 will be left pending. Is there any objection? Hearing none, Chair leaves House Bill 218 left pending. So you want to come back? Or? Yeah. The Chair turn the meeting back over to Chairman Moody.
Thank you, members. Is it? You got it? Boy, you're going to have time to kill before we go to the House floor. I should have scheduled 3 or 4 more bills. I know you all did some thinking about some of these bills, and I do want to pull up some of the bills we've heard today to vote, to move. I made a commitment last week that we were going to be efficient, effective, and respectful. I think we've kept that commitment here today, and as part of that, we want to start moving some of these bills that do not have conflict forward out of this committee so that they can get broader consideration. With that, the chair moves that House Bill 247, without amendment, be reported favorably to the full House with the recommendation that it do pass and be printed. This is Dean Thompson's bill relating to the consideration of a subsequent writ of habeas corpus in certain felony cases. Second, and I'll remind you of some of the facts that she gave us, let's see. This is a bill last session that was voted out of committee 9-0 and out of the House floor 146-0. Just for reference. Any questions or discussion on the measure? No? Clerk will call the roll.
Chair Moody,
Aye.
Vice Chair Cook,
Aye.
Representative Bojani, Representative Bowers, Representative Darby, Representative Harrison, Representative Leach, Representative Christina Morales, Representative Schatzline. 9.
There being 9 ayes and 0 nays, the motion prevails. Okay. Chair lays out as a matter of pending business House Bill 270. Members, this is Dean Thompson's bill relating to the post-conviction forensic DNA testing. By way of background, the committee vote of last session was 7-0, And there was one foolish person that voted against, no, just kidding. It was 145 to 1. I'm sure Dean Thompson will exact her revenge. That was last session's vote, just for reference. Do we have any discussion or comment? Okay. The chair moves that HB 270 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
Aye.
Representative Bojani? Aye. Representative Bowers? Aye. Representative Darby? Aye. Representative Harrison? Aye. Representative Leach? Aye. Representative Christina Morales? Aye. Representative Schatzline? Aye. 9.
There being 9 ayes and 0 nays, the motion prevails. The chair lays out as a matter of pending business, House Bill 286 by Dean Thompson. This is relating to the procedure for an application for a writ of habeas corpus based on certain new evidence. By way of background, this had a committee vote in that last session of 9-0 and a House floor vote of 143-0. Do we have any questions, comments, discussion? No? The chair moves that House Bill 286 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody?
Aye.
Aye.
Vice Chair Cook? Vice Chair Cook?
Aye.
Representative Bojani? Aye. Representative Bowers? Representative Darby? Representative Harrison? Representative Leach? Representative Christina Morales?
Aye.
Representative Schatzline?
There being 9 ayes and 0 nays, the motion prevails. Chair lays out as a matter of pending business House Bill 381 by Dean Thompson relating to the applicability of the death penalty to a capital offense committed by a person with an intellectual disability. By way of reference, there was an 8-0 committee vote in 2021. The last floor vote was in 2019 and it was 102-37. Do we have any questions, discussion, comment? No? The chair moves that House Bill 381 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
Aye.
Representative Bojani? Aye. Representative Bowers? Aye. Representative Darby? Aye. Representative Harrison? Aye. Representative Leach? Aye. Representative Christina Morales?
Aye.
Representative Schatzline?
There being 9 ayes and 0 nays, the motion prevails. The chair lays out as a matter of pending business House Bill 611 by Chairman Capriglione relating to the creation of the criminal offense of unlawful disclosure of residence address or telephone number. Is there any, we don't want to do that this early. There's no, they're not going to take one up for.
Yeah, that's fine. He requested it.
He really did?
Yeah, but you're right. It's this early.
Is this early? I wouldn't do it, and also because there's like ACLU concerns about it. People won't vote against this. Okay, he's gonna, someone will probably do it. I would just do it. Okay. No, I know, we're good. Okay, the chair moves that House Bill 611 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
Aye.
Representative Bojani? Aye. Representative Bowers? Aye. Representative Darby? Aye. Representative Harrison? Aye. Representative Leach?
Aye.
Representative Christina Morales?
Aye.
Representative Schatzline?
There being 9 ayes and 0 nays, the motion prevails. Members, that's all that I have in terms of voting bills. I want to thank you for your quick work and attention to all these matters. We have a busy several weeks ahead of us, so thank you for being on top of everything. We'll try to make sure that we get everything to you as quickly as possible so that we can continue to be efficient. Members, that concludes today's agenda. If there is there any further business for the committee to address? If not, the chair moves to adjourn. Is there objection? Hearing none, the committee stands adjourned at 1:40 PM, subject to the call of the chair.